Do you consider back to mention item number 6 here, Raj?
Yes.
Can it be listed after 3 weeks, Raj? Executing agreement on behalf of Mr. K. N. Chaudhary, Raj.
On the prayer of learned counsel for the writ petitioner made with the consent of the opposition party. Admission hearing of these matters can schedule for 3 weeks.
Much obliged, Raj. May I please have paid for listing motion matter tomorrow, Your Lordship. Yesterday I have filed this petition.
What is the matter?
The matter relates to silencing the disciplinary proceeding, Your Lordship.
Monday?
Monday. God bless.
May I please, Lordship? Lordship, I beg to mention for listing on WBC, Lordship, matter pertains to appointment of the driver of the district court of Kokrajhar, Lordship. They have conducted the interview, but currently they selected the less qualified candidates, Lordship.
How do you know they are less qualified?
Lordship, he is a Lordship. We have already participated in the interview, but he's a driver, so his skills is less than me, Lordship. That's why.
So you want motion?
Lordship, orders. Lordship, it was a long pending matter, Lordship.
Next Friday. Next Friday.
Yes, sir. Much obliged, Lordship.
My lord, for item number 20, may you be pleased to refer the matter to some other bench as my senior Mr. Jyotimoy Roy is engaged.
Item number?
20.
List before any other bench without me.
Much obliged.
May I please, Your Lordship? Lordship, I beg to mention a writ petition matter for orders. The matter may come up after 2 weeks. Much obliged.
May it please your Lordship. Lordship, I beg to mention for listing a writ petition, Lordship. On Monday, Lordship.
Listing for what?
Listing for motion, Lordship.
What is the matter?
Matter relating to, Lordship, implementation of a mini scheme, Lordship.
Implementation of a?
Mini scheme, Jal Jeevan Mission, Lordship.
Yes. What do you want?
Lordship, on Monday, the matter may come up, Lordship.
No, that is a bench for matter. It is not a service matter.
No, Lordship.
This bench is for service matters. You go and mention before the appropriate bench.
Obliged, Lordship.
May I please, Your Lordship? Your Lordship, the matter, I beg to pray for listing an urgent matter. We have filed on 28. Your Lordship, the matter is related to transfer. So can it be listed tomorrow?
Transfer.
Obliged.
Although it is part heard, it has been quite some time. If your Lordship so desires, I can refresh.
Please.
I won't trouble your Lordship too much with the documents. I think just a narration of the facts. There was a tender for supply of liquid nitrogen, 12 lakh liters. It was split up into 1 lakh liters per year. There was a set of
1
eligibility.
lakh liter per year or per month?
Per month. Now, there were, as in all tenders, there were a set of eligibility conditions. Now, I submitted my tender. They find that there was only one single tender. On that ground, they modified one of the eligibility criteria. The requirement was that the parties should have past experience of supply to government or government agencies. And it should be for 3 financial years. They removed the condition of supply to government or government agencies and they reduced it to 1 financial year. That is how the private respondent comes in. He submits his tender. Once the tenders were opened, a comparative statement was prepared, which is part of the records. That itself will show that he could not meet the other conditions also. In spite of the relaxation, he could not meet any of the conditions. We submitted a representation. Nothing was being done. In the meantime, they issued a supply order in favor of us for 4 lakh liters, which led to a natural presumption that the remaining 8 lakh liters has been given to them, which now is an admitted position. Under the statute, there is a provision for appeal. We filed an appeal pointing out objectively that these were the eligibility criteria and this is how he could not meet even one of them. The appellate authority accepted our contentions, upheld them and said that you could not have awarded the contract to the private party. And you should cancel his bid. Now, they, instead of cancelling his bid, they cancelled the entire tender. After having awarded 4 lakh liters to me, even that part was cancelled. And they issued a fresh tender. Now, again for 12 lakh liters, by doing away with all the eligibility conditions. Now, that is what is under challenge. So far as the 4 lakh liters is concerned, your lordship is aware, the law is very clear. Once you have awarded, you cannot take it away without notice. Now, what remains is the remaining 8 lakh liters. So far as the 8 lakh liters is concerned, our contention is, firstly, under this statute, the rules that have been framed, the rules say that once a tender is floated, there cannot be any question of relaxation of any of the eligibility conditions. So this being a continuation of the earlier tender process, in the new tender also, you could not have done away with the eligibility conditions. That is the first contention. Second contention was, the appellate authority's order has attained finality. No one has questioned it. It was very clear that you cancel his bid. Had that been resorted to, the remaining 8 lakh liters would have gone to me. So far as the 8 lakh liters is concerned, the challenge is to that extent. But in a nutshell, that is, if your lordship so desires, I can place the documents. If your lordship will first come to the NIT itself.
That is 26th of May 2022, is it?
Precisely. Page 38 is the NIT. Your lordship will first come to page 28 itself.
Yes.
In the box that has been chart that has been prepared, your lordship will find total quantity is 12 lakh liters. And page 66 will reveal that this 12 lakh liters is split up into 1 lakh per month. There's a reason why I'm pointing this out.
Yes.
Page 66 will show that it is 1 lakh liters per month. 5.1 subclause 1, small Roman 1. Now, if your lordship comes back to page 38, another thing that is important is that this is a procurement under the Assam Public Procurement Act 2017 and the Assam Public Procurement Rules 2020. Subclause B will show that. Now, if your lordship kindly turns to the eligibility conditions at page 65.
Yes.
4.2.1, the bidder, if not the manufacturer, should have the installed capacity of supplying goods of similar in nature to different government departments, undertakings, entities of 1 lakh liters quantity per month during last 3 financial years, 1920, 2021, 21-22. 4.2.2, the manufacturer of the quoted goods should have valid manufacturing license and an experience of manufacturing and supplying of at least for 3 financial years ending on 31st March 2022. Detail of supply, similar contract for during the last 3 financial years, etc., needs to be furnished. Then 4.2.3a, bidder must have own production plant or bulk storage facility minimum capacity of 1 lakh liter per month in Assam. That is important one. Details of cell phone infrastructure should be furnished. Now, C, location of plant storage facilities should not be more than 150 kilometers from the operational headquarters of ALD at Khanapur. These are the relevant eligibility criteria. There is a reason, my lord. This party, this was amended. There was a corrigendum issued at 101. This corrigendum will show this corrigendum will show 2 facts. One, they say that there was a single tender. So therefore, this
Just a minute, Mr. Chaudhary. What was the last date of submission of bids?
last date was, my lord, 17/6/22.
Where does one find it?
It is at page 38 itself. Subclause E.
Last date was 18/6.
17/6. 18/6 was the date of opening. Subclause E will show.
Yes, suppose. All right.
Now, page 101.
Hmm.
On 18/6, they issued a corrigendum, and the modification that is made is capital A. Malab. Although it says that by virtue of this corrigendum, 4.2.2 is being modified, but if your lordship peruses the language, your lordship will find that this is actually 4.2.1 that is getting modified. The bidder, if not manufacturer, should have installed capacity of supplying goods of similar nature up to 1 lakh liters per month in multiple consignment during the current financial year. So 3 financial years is relaxed to 1 financial year, and the requirement of supplying to government or government agencies is removed altogether. So now anyone who has supplied even to some private party, which may remain unverifiable, even then that was acceptable. We said, all right, you are saying that since there was a single tender, we did not object to this. Now, my lord, once the tenders were opened, very next page, your lordship will find the comparative statement.
Yes.
And your lordship will find a chart has been prepared. I am Premier Cryogenics and Meghalaya Oxygen is the private respondent. Your lordship will come to, I'll quickly point out the serious lacuna. Serial number 4, manufacturer's authorization. Your lordship will see Meghalaya Oxygen submitted the authorization letters issued by SD Cryogenics Gases Private Limited, Sanrup Jhongkhar, Bhutan. Forget Assam, it is not even in the country. Now, serial number 11, manufacturing production capacity per annum. I have a capacity of 70,56,720. He has that SD Cryogenics has a production capacity of 37,500. Now, serial number 13, the requirement is of supplying 1 lakh liters per month. My storage capacity is 2,56,442. And your lordship will see the response number 6. Location of storage, Sanrup Jhongkhar, Bhutan. Again, not even in the country. Amingaon, Kamrup, storage capacity 40,000 liters at Amingaon. Now, instead of rejecting his bid, what they do is, against the remarks column, your lordship will kindly see, I have been marked as responsive. He is allowed to improve his tender, to submit shortfall documents within 21/7/2022. More than 1 month now goes by. If your lordship now turns the page, this is how the tender committee considers his shortfall document. Page 103. Does not even mention what are the documents that are, how he has been able to show the improvement in the storage capacity, which is a mandate of the tender. Nothing is recorded. They simply say, bidder's credentials regarding supply chain mechanism with producer in Bhutan were thoroughly verified by the committee. The committee is of the opinion that the understanding between the producer and stockist is pre-existing and the possibility of any interruption in the supply chain of liquid nitrogen is unlikely under the present circumstances. The FDI document is not related to the supply chain and its validity is not a matter of concern for the purchaser. Hence, the committee is satisfied that Meghalaya Oxygen, etc., will be able to supply liquid nitrogen to LLDA on a continuous basis with the existing infrastructure of producer in the Indo-Bhutan border area adjoining Tamulpur district of so-and-so. The technical bid evaluation committee recommends parallel procurement of liquid nitrogen from both technically qualified parties at the lowest quoted rate of operational advantage and uninterrupted power supply chain. Now, there is another interesting thing in this document, my lord. Your lordship will find a signature of one Mr. Bokhanto Kakuti at the bottom.
Yes, he retired before the.
He had retired on 31/7/22. Now, when we realized all this is happening, we submitted a detailed representation at page 105. And what we say is this one. As per clause 4.2 of NIT, all bidders have to meet 6 qualification criteria to be technically qualified. As per technical bid evaluation committee report uploaded in portal Meghalaya, etc., with backup of manufacturer SD Cryogenics, Bhutan has been declared technically qualified. We have gone through the bid uploaded by them as available in the portal and submit that they do not meet even one of the qualification criteria. Whereas the comparative statement prepared have not deliberated on some of the qualification criteria at all. And in the others have relied on the quotation of the bidder without any supporting document, etc. Now, not only is the bidder not meeting any of the qualification criteria, but it claims to be operating liquid nitrogen storage tank and transport tankers without the mandatory license issued by Petroleum and Safety Organization, Government of India, which is an offense under Explosives Act, punishable by imprisonment up to 3 years, etc., etc. Now, if your lordship kindly turns the page, the enclosure to this representation,
Yes.
we have quoted each of the qualification criteria, and we have clearly and objectively indicated how he does not meet any of the qualification criteria. And this pertains to each of the qualification clauses. I am not troubling your lordship in detail, because this is what, when they did not respond to our representation, this is exactly what we filed before the appellate authority. That your lordship will find, what was I to appeal to?
128.
My lord. And your lordship sees from 129, exactly like in the representation, we have objectively identified how he does not meet. We have prepared a chart, pointed out the requirement in under the NIT, and we have on the right hand side, we have indicated how he does not meet any of the criteria. And the order passed by the appellate authority, your lordship will find at page 138.
Yes.
Page 139
Yes, please.
is the order pass, grounds of appeal, terms of reference, etc. The qualification criteria is indicated, then towards the right, compliance by MOPL. No document has been uploaded by the bidder that either the bidder or the manufacturer has made any liquid nitrogen supply to any government entity. The manufacturer has started operations in November 2021. That is why, my lord, it was relaxed from 3 years to 1 year. It clearly does not have experience of 1 lakh liters per month during the last 3 financial years. Refer to document uploaded by MOPL titled Years of Experience in Similar Line of Activity, enclosure C. The qualification criteria is not deliberated in the comparative statement of technical committee. Now, next criteria, my lord. On perusal of the papers as well as the bid documents of the bidder, it has been found that the bidder is not responsive to the qualification criteria, as the bidder itself has stated in the bid document that it has the experience of producing industrial gas only. They have set up 40 TPD ASU plant at Bhutan, 100 kilometers from Guwahati in November 2021. Hence, there is no evidence to the fact that the bidder has installed capacity of supplying liquid nitrogen gas, and they did not have either the installed capacity or the experience to supply liquid nitrogen gas during 2021. Bidder has not claimed in the bid that they fulfill this criteria. Now, against the next clause, Malam, they have installed capacity of 40,000 liters of liquid nitrogen gas storage tank in Amingaon, Assam, which falls short of 1 lakh liters. The bidder did not have license or liquid nitrogen tank at the time of bidding, and the committee has not gone into the details of the claim of the bidder that they have 40,000 liters liquid nitrogen installed capacity. In consideration to the aforementioned and infirmities, it appears that the bid submitted by Meghalaya Oxygen, etc., is non-responsive as per Section 11D of the Assam Public Procurement Rules, so and so, wherein it is stated that the bidder must fulfill the eligibility criteria given in the bidding document, etc. Conclusion: the undersigned is of the opinion that the NIT evaluated by the Assam Livestock Development Agency is contrary to the provisions laid down in Section 10D of the Assam so and so rules. Bid of Meghalaya Oxygen being a non-responsive bidder was accepted by the technical committee in violation of 10D of the so and so. Hence, the bid is recommended to be cancelled. Now, my lord, as I was pointing out to your lordship, in the meantime, 1 lakh liter, 4 lakh liters was awarded to us, which your lordship will find at page 125.
Page 121.
125.
Yes.
With reference to the subject cited above, I am to inform you that the competent authority of ALDA has approved lowest responsive rate for supply of liquid nitrogen to Assam Livestock Development Agency, etc. X source factory rupees so and so, so and so. As such, you are allowed to produce and deliver an approximate quantity of 4 lakh liters of liquid nitrogen in 12 months with effect from so and so. So this was awarded to us, which leads to a natural presumption that the remaining, because the recommendation was supply from both parties, take supplies from both parties. So natural presumption is that the remaining 8 lakh liters was given to him. Now, this 4 lakh liters anyways could not have been cancelled. They cancelled the entire tender, which your lordship will find at page 141. Due to unavoidable circumstances, whereas at the lowest rate, it has already been awarded to us, 4 lakh liters already awarded to us. Due to unavoidable circumstances, the tender process for procurement of so and so is hereby cancelled.
Yes.
And your lordship will kindly note the date.
Yes, please.
13/9/23, 13/1/23, and the next page, I'm sorry, my lord, what was it? 91, 149, page 149. Same day, and this time they do it in the GEM portal, so it goes outside the purview of the appellate authority this time, and your lordship will find the eligibility criteria at 155. Nothing. Each of the eligibility conditions in the earlier tender. How will they verify whether the parties who submit tenders have any experience at all? The only criteria is qualification of bidders, location, plant, storage facility, collection point should not be more than 150 kilometers from the operational headquarters of ALD at Khanabad. The fact that the requirement is to supply 1 lakh liters, whether you have the storage capacity, whether you have the financial capacity, whether you have any past experience, nothing much. This is the first NIT I have seen where there is no eligibility. This is the extent of favoritism that has been resorted to just to bring in the private respondent. Now, my lord, if your lordship kindly peruses one of the grounds, so far as the 4 lakh liters, I am not even troubling your lordship. So far as the balance 8 lakh liters is concerned, the challenge is on 2 counts. Firstly, the rules say that once you have initiated a tender process, there is no scope for rules on court. Extra copy or something. It's a very voluminous set of rules, my lord. I have just given the relevant. In the 4th page, your lordship will find Rule 23. This provides for procedure relating to invitation, submission, opening and evaluation of bids and constitution of committees. And if your lordship kindly comes to sub-rule 16 at the next page,
Yes.
sub-rule 1 thereof, subject to the provisions of section 7 and section 14 of the Act, technical bids shall be evaluated solely on the basis of the criteria or terms and conditions set forth for evaluation of technical bids in the bidding documents and in accordance with the procedure herein in this rule. The criteria and terms and conditions shall be clearly mentioned in the bidding documents so as to maintain transparency in the evaluation and selection process. Such criteria or terms once fixed or for evaluation of technical bids in the bidding document shall not be changed or relaxed under any circumstance. Bids shall be evaluated only against the criteria specified in the bidding documents. Now, my lord, they will say that now this is a new fresh tender process. So there is no question of relaxation coming in. But this is a continuation of the tender process that you have done. And it was based on the criteria that was fixed, was based very objectively on what was the requirement, supply 1 lakh liters. So you have to have a storage facility of 1 lakh liters. It had a clear nexus with the object that was sought to be achieved. Now, they have completely done away with all past experiences, storage capacity, everything. So therefore, my lord, and in any case, your lordship is aware of the law, which is very clear, that if terms and conditions of tender are so designed only to favor someone, there, otherwise the scope is very limited when your lordship is exercising jurisdiction under 226. But when it is designed exclusively to favor someone, that is when your lordships acquire the jurisdiction and your lordships will intervene, because this is a clear mala fide exercise of powers. So that is my submission before your lordship.
So what is the relief you are seeking?
Relief, my lord, so far as the 4 lakh liters is concerned, the tender could not have been cancelled. That 4 lakh liters, they have to proceed with me, continue with me. So far as the cancellation of the tender itself is concerned, that is contrary to the appellate authority's conclusion and directions. So they could not have,
That's the same thing. 1 and 2 are same grounds.
because there the balance 8 lakh liters also comes in.
Correct.
So that is why this ground would very much be, because if his bid had been cancelled in terms of the appellate authority's directions, then the only option would have been to give the 8 lakh liters to me, because I would remain the only responsible.
That still is in the realm of an option, not a compulsion.
Not a compulsion, but then the second limb comes in, man. If you have to, assuming I don't have an indefeasible right for the balance 8 lakh liters, even then, if you float a fresh tender, you could not have done it only for the purpose of bringing in someone. On that count also, the NIT has to go.
No, taking things forward from the last hearing, which
Mal.
I faintly remember, insofar as 4 lakh liters and protection of your client's interest concerned, that on the face of the record, the court is inclined to accept your argument, subject to what they say. Because the appellate authority's order, if that is the basis, then that order clearly hinted at they can't cancel your tender, or appellate authority cannot nullify your tender on the basis of your appeal. So that question doesn't arise. Insofar as the other 2 prayers are concerned, those have 2 obstacles. So if you kindly address the court on that, then we'll move on to that.
One of the things they have taken, in fact, in the affidavit also, they have taken the point that they wanted, since that would leave a single tenderer in the fray, and they wanted to widen the participation. Now, the recent CBC guidelines of 2021 has done, in fact, my lord, may I place that?
Mr. Chaudhary, please listen. What has happened prior to cancellation of the tender, this is no longer a live issue here. Because the appellate authority has accepted your appeal, you have challenged the award given to them for the remaining 8 lakhs, or on an assumption that the balance part will go to them because their tender has been accepted.
That is now an admitted fact that they have given the 8 lakh.
Correct. So that is no longer a live issue because the appellate authority has declared that, they have not assailed it, and the authorities have acted upon it. So in doing so, they might have exceeded what was required. That can be corrected. Rest of the matter, whether their tender was valid, whether they were eligible, this is no longer a live issue.
It has already been
It's
taken.
gone. So the 2 aspects which I was mentioning are as follows, and please address the court on that. Number 1, when the corriendum was issued, that was not challenged by your client.
We did not.
That was. So the corriendum, obviously, let's take it that it was designed to bring in the private respondent. Let's assume it. Had they met the requirements, then that chapter would have been over. But even the corriendum, if it is accepted, even then they did not meet the requirement. So whether the corriendum was rightly issued or not,
I'm
is
not on that.
Not a live issue. So if the corriendum was rightly issued and had they qualified, then their candidature or their participation could not have been
Could not have been
reopened.
questioned.
This is number one. Number
That I'm
two,
accepted, stated.
yes. Number two, even the award letter, which awards 4 lakh liters to your client, that is not under challenge in any proceeding.
No,
Is that correct? So therefore, you have accepted the fact that out of that tender process, your client has got 4 lakh liter and you have accepted that. You may not be satisfied, but you have accepted. So insofar as this 4 lakh liter is concerned, you have accepted that that is the outcome of the tender process insofar as your client is concerned. Now, the question would be that whether the entire tender could have been cancelled. Obviously, the court has indicated what is the prima facie, and we'll ask them to satisfy, otherwise this remains. Second is, can there be a mandamus to them to issue the balance 8 lakhs to your client? Probably not. Probably not. If you want to argue on that, you can argue. No, what I'm saying is, I'm not precluding you.
No,
because
no, I appreciate, but
there could be.
I wouldn't like to stretch it
That's
too
right.
far.
So there could be legal fictions which may require consideration, but prima facie it appears you cannot ask for that mandamus because you have accepted the 4 lakhs without any demur. The last aspect is by relaxing or doing away with the earlier stringent or whatever conditions you may say. Is it that they have done it only to favor the private respondent? Probably yes. Probably yes. But there can't be a clarity in the matter for the court to give a determinative opinion unless the tender process itself is concluded. Supposing more than 2 bidders participate, that is yourself and private respondent.
Now, Malak, what they have, if your lordship compares the eligibility condition, not just the private respondent, people who do not have any experience at all will come.
That's right. But that again takes us to a very difficult zone.
My instruction is that once again, only 2 bidders have participated pursuant to this second.
Correct. But then is it not open for them to design the terms and conditions of the tender? Supposing they say yes, if we don't do it, then only one party can participate. Then
that is what I was about to point out, Malak. Earlier, the CVC guidelines said that if there is a single tender, you should cancel the tender process and retender. Nowadays, only because there is less participation, that cannot be a ground.
no, that's correct. That is an issue which will be relevant at a slightly different stage. If it turns out that there is only single eligible bidder, then if they cancel it, then this could be a relevant factor. But at the moment, they are relaxing the terms of the tender. Is there any law that they can't do it?
Well,
Obviously, they are doing it to expand and allow more participation,
But-
which could be keeping in mind somebody's interest.
now, just thinking aloud, Malak. Assuming over a period of time, there are no lawyers who are coming forward. Would eligibility condition be fixed that even LLB is not required for a judicial officer's appointment? It
That
is-
analogy, I'm sorry, Mr. Chaudhary, that cannot be accepted in a tender. See,
Here they are not putting any conditions at all.
You are very well aware that the scope of investigation or inquiry by the Reed Court in these matters are on some very well-defined
Yes,
parameters.
absolutely, no doubt about it.
Whether there is a violation of Article 14, discrimination, favoritism, right? Now, favoritism is when they do it by violating the terms they have themselves set. That is when favoritism comes in. But supposing they come up with a very liberal terms, which is not favorable to one of the, say, your client, they have their commercial interest. Your client has a commercial interest. Mr. Datta's client has a commercial interest. So if you can stop him, then you gain. If they can cut you short, they gain. These interests will always be there.
Certainly.
And therefore, the arguments will be molded in terms of whatever is the driving force. That's perfectly understandable. But I am on the question of what is the legal principle we apply.
Legal principle is, my lord, your lordship is absolutely right. I am not even, I am the last person to stretch it to that extent. What
No,
I am-
but you must do it. That is when this law will be tested.
But that is exactly what I was coming to. It is one thing to say, what is the law? The law is that it is open to the authorities inviting the tender to suitably design the terms of invitation to tender as per their requirements. On that, there can be no quarrel at all. Here is a case where they are completely doing away with all terms of invitation to tender. There is no criteria at all. So would your lordships permit what is the test? When a term of invitation to tender is fixed, the test that is applied is, it has to have a nexus with the object that is sought to be achieved. Now, the earlier tender, a comparison will show that there was a clear nexus, that 1 lakh liters requirement per month. So therefore, 1 lakh liters storage capacity you have to have. Now, I can understand that 1 lakh liters being reduced to, say, since it can be spread over a period of 1 month, they may say that, all right, you can have a storage facility of 50,000 liters. But to completely say that, do away with that storage capacity at all, is it not stretching it a little too far on the part of the authority?
It is, but they are entitled to. They are the employer.
That I appreciate.
So if they want a caterer to participate in the bid, it is for them. It is for them. Once there is a
When public
selection-
money is involved, when public interest is involved,
That's
your
right.
lordships not intervene. That
No, public money involved is the question of transparency, question of relevancy will arise only when there is a selection.
no.
But participation cannot be stopped.
If it is based on, those are the areas, if your lordship recalls, I don't know whether I'm carrying that judgment, Meerut Development One. Your lordship recalls, the only exception when it comes to terms of invitation to tender, the only exception that has been carved out in Meerut Development Authority is that when it is designed in such a way to suit, once they find that he does not qualify at all, they issue a corrigendum in such a way that 3 years is, now it is evident from the appellate authority's order that they had set up the plant only in 2021. So that 3 years financial criteria was obviously designed to suit them. In spite of that, we did not object. Now, requirement of supplying to government or government agencies was done away with because their supply has been only to a private organization called WAMUD. That also we did not object. But you do not meet any of the criteria. And now, once the appellate authority has conclusively held, and now it is part of the records undisputed. No one has questioned the appellate authority's order.
Which
With-
paragraph you want to rely upon?
Meerut Development, my lord. Para 26.
Yes.
Para 26. A tender is an offer. It is something which invites and is communicated to notify acceptance. Broadly stated, it must be unconditional, must be in the proper form. The person by whom tender is made must be able to and willing to perform his obligation. The terms of the invitation to tender cannot be open to judicial scrutiny because the invitation to tender is in the realm of contract. However, a limited judicial review may be available in cases where it is established that the terms of the invitation to tender were so tailor-made to suit the convenience of any particular person with a view to eliminate all others from participating in the bidding process. Yes, the last portion qualifies that with a view to eliminate others. But when it is so designed that there can be no other conclusion but to say that otherwise this person would not qualify. All terms done away with. This does not eliminate me. To that extent, I am not saying that. But it is so designed, which is glaring on the face of the records, that he does not have any of the eligibility criteria. Just to bring him in, all conditions done away with. Will your lordship allow that? That is the question that I am posing before you. And we have prepared a chart, my lord, how drastically it has been done just to make a comparative analysis. If your lordship, this is a comparison of the two. Now that they have done it in the GEM portal, how drastically it has been compromised. Your lordship, if your lordship compares the two, your lordship will find that none of the criteria that were required, basic criteria even is missing in the new tender.
But Mr. Chaudhary, accepting your argument, where does it lead this court to? We have to say that, no, you must have these criteria.
No, I am not, I am the last person to say that.
Then what?
I am very conscious about the fact that your lordships cannot or will not issue a mandamus saying that these are the conditions you should incur upon. But your lordships certainly can hold that here is a situation. The facts are so glaring that he could not have. So therefore, your
That's
lordship.
all right. Supposing this argument is to be accepted, this NIT has to be set aside,
Yes.
and we have to say that you have to have these criteria, then?
Your lordships will say that you will design the criteria which has a nexus. Eligibility conditions have a nexus with the object that you are seeking to achieve.
No, what is it? For example, what is it?
That they are the best judge. They will frame. But these, whether your lordships will accept, that is the question that I'm the last person to say that your lordships will specify that put these conditions, put that condition. Neither this honorable court nor we have the expertise. It is the authorities who have the expertise. But to completely do away, will your lordships give them such a wide handle so that they can get away with such kind of
No,
arbitrary
it's
exercise?
not about giving them an angle or not. We are not sitting over appellate bodies over tender matters.
Certainly.
We are only to examine whether any party has been wronged, whether the constitutional rights of any of the parties has been violated. That's the only question.
And also, Malab, with greatest respect, whether there is fairness in the decision-making process, whether the facets, because unequals being treated equally is also an integral facet of
That
Article
could be a relevant argument, but that's why I was asking you, would you like to reserve this argument
4
till the
at a
time?
later stage.
Yes, it will be better for many reasons.
And,
Why don't you consider it that way?
I am
If you make that clarification, we'll not go into this aspect and keep it open. Will it not be
the
ultimately a
problem with
good idea?
the only otherwise, your lordship is absolutely right, Malab. The only problem that I foresee is what will happen is now the only thing that will decide this tender is the price. Now they are a new entrant. They will your lordship has had the occasion in one of the cases that I had argued, this speculative bidding. They will resort to speculative bidding, which we will not perhaps be able to match. And they will, once we challenge, they will say that there is no eligibility criteria, so we meet all the eligibility criteria. There's nothing, no ground that will be available to us.
So that you may have some logic there, but it will be a preemptive argument at this stage. Whether it sounds sound or not, these things can be looked into at an appropriate stage. This is too premature a stage.
In that case, your lordships will leave all these issues open to us for a challenge if deemed appropriate at a later stage.
Let us see.
Malab.
Yes, Mr. Nathan. What is happening?
Well, the lordship has seen the order at page 122. Sorry, 125.
That is the award letter.
That is the award letter. This work order, supply order
Please
has been
first
issued.
tell me what are your submissions?
Well, my submission would be, under the peculiar facts and circumstances of this case, the authority has to take a decision after the appellate authority's order. In fact, on 4/11/2022, they have finalized the tender process and issued the supply orders to both the parties. And here the important thing is, the supply order dated 4/11/22 was issued at L1 rate. Lordship may kindly consider that L1 rate.
Mr. Nath,
The L1 rate was the rate of the.
only thing that is stopping from court is because he did not challenge the award letter. Otherwise, how can you do it? How can you do it? How can you split the tender in between? You're changing the corrigendum. Are these not clear instances of mala fide exercise? But he did not challenge it. Had he challenged it, the matter would have been over. Just because he has accepted the award letter, at this point of time, he cannot challenge it. Because these are pure commercial transactions.
Yes,
But had he challenged it at that point of time, in any form, you tell me how you can do it? You are issuing a bid to give this work order or work to some tenderer. Whatever you have changed the terms, these, that, whatever, it's a different thing. How can you split the work? And why 4 lakh and 8 lakh? Why not 5 lakh, 5 lakh? Why not the reverse? So this is complete arbitrariness going on here.
but
Complete arbitrariness.
in fact, Malad, the authority, we are concerned with the rate, Malad. We have
Oh.
by giving this order, they have not compromised with the public money, Malad. Which is involved in this case, Malad. Malad, kindly see, on 4/11/22, Malad, the order was passed at L1 rate. L1 rate, the authority have considered the L1 rate on the basis of that tender process, and that belongs to the respondent number 6.
Hmm.
That is the rate quoted by them. So Malad, when the appellate authority has held that the tender bid of the respondent number 6 is invalid, but the offer of the respondent number 6 being an invalid bidder, it also has no validity, Malad. So ultimately, Malad, the L1 rate which was considered by the authority and the work order was issued on 4/11, that doesn't remain in the picture, Malad.
All right, go ahead. Hmm.
So, Malad, the
What-
appellate authority,
is there any principle of law which supports your argument?
Malad, invalid, the rate quoted by an invalid bidder
Hmm.
has no, has,
You
has,
have awarded in the contract, Mr. Nath. You are questioning your own wisdom, your own decision.
Malad, at that stage, because the appellate authority order came later,
The
Malad.
stage is, forget this stage.
Appellate authority order came later. Appellate authority order came on 4/1,
Right,
and
but
the order was
Mr.
issued.
Nath,
Lordship.
I am asking pointed question not to unsettle anyone, but to quickly come to the main point.
Malad,
We as judges, we have to ask this
Lordship.
questions. Otherwise, this matter can be hard for next 3 days. But you know, it doesn't happen in this court.
Nothing.
There are others waiting
No,
for their
correct,
cases.
correct,
Please tell me one thing very clearly and address the court on that.
Lordship.
There is only one live issue here, as I can see. That is, even if you cancel the tender, how can you take away the award which was given to the petitioner because there is an order passed by an appellate authority on an appeal filed by the petitioner?
Malad, the explanation to that, Malad, what I am submitting, that we have already given in the affidavit. The reason, ultimately, the decision-making process I am expressing. for
Where is the
Lordship.
explanation?
Malad, in paragraph 8 of our affidavit, we have stated that
Hmm.
under what circumstances the authority had to take that decision, Malad.
Yes, paragraph 8.
Paragraph 8.
This is affidavit filed by respondent.
Filed by
3 and
the,
4.
yes, Malad, filed by the respondent number 2, 3, and 4, Malad.
All right.
At page 171, internal page 14, Malad.
Yes.
But para 8, that with regard to the statements made in paragraph 12 of the writ petition, the deponent denies that upon cancellation of the supply order issued to the respondent number 6, the same ought to have been awarded to the petitioner company. It is also denied that the authorities of ALDA has issued the order dated 13/1/23, cancelling the NIT dated 26/5/2022 in deviation of the order dated 4/1/2023 issued by the appellate authority. In this regard, the deponent respectfully states that after receipt of the order dated 4/1/23 passed by the appellate authority, the ALDA has found that the L1 bidder pursuant to the NIT dated 26/5/2022 have been found to be invalid, and in the tender process only one valid bidder remained. The authorities considered that in the interest of the uninterrupted supply, L1 bidder was placed order for supply of 8 lakh liters at the lowest rate, and L2 bidder was placed order for 4 lakh liter at the L1 rate. The total order placed was for 12 lakhs liters valued at rupees 105.48 lakhs as per L1 rate. If the order is placed at L2 rate to the petitioner, the order value will be rupees 159.36 lakhs, and the ALDA have to incur excess expenditure of 53.88 lakhs. If the petitioner is allowed to supply the entire 12 lakh liter of liquid nitrogen at their quoted rate. Further, the tender process has become a single process without any competitive rate, which is not in the tune of the CVC guidelines. Therefore, in such a situation, the authorities have decided to cancel the entire process and invite retender by reconsidering the conditions that more interested parties can participate and the ALDA may get more competitive rates of liquid
So
nitrogen.
is the L1 a competitive rate? L1 rate,
The L1,
is it
Lordship,
competitive?
Lordship, kindly come to page 9, Malab, the internal page
No,
9.
no, I'm asking you, as per your instruction,
Malab.
the rate submitted by L1, is it a competitive rate?
Malab, between
That is acceptable rate? Given the balance 8 lakhs at that rate,
two bidders were there,
you
Malab.
would like to do it?
We have already accepted. 4 lakhs at that rate.
Do it.
We have accepted that rate.
Malab, this submission is not there is no material on record to show that they are ready to supply the entire thing.
They'll file an affidavit tomorrow.
No,
We have already filed and we have not challenged that order
In
at the
fact-
lowest rate.
In fact, in the writ petition, the prayers made in the writ petitions are something else, Malab. Not to that effect, Malab. So Malab, the reason for taking that decision for cancelling the entire process and the going for a retender is given here, Malab. Malab, the L1 rate, there are two bidders they found and in comparison to both the tenderers, they found that this is the
Mr.
L1.
Nath, I'm
Kindly
just
see the
asking
page
again
9.
for clarification. You have awarded the work for 4 lakh liters to the petitioner at the rate quoted by the private respondent, which was the
Right.
L1 rate,
L1 rate,
correct?
yes.
Does it not, on the face of the record, contradicts what you're projecting in page para 8? Because he's saying, you are saying that if we give him entire 8 lakhs, that will entail additional expenditure.
Malab.
He's saying we'll do it at the rate of L1.
No, that is, in fact, Malab, in the writ petition, there is nothing. Malab.
Oh, he has
If-
accepted the work order.
No, he accepted, but he has not, in fact, Malab, he has not executed it, Malab. No supply has been made, no agreement has been executed, no, Malab, in fact, in the writ petition, they have the performance guarantee has been annexed, but it is not submitted to the authority, Malab.
So that is your matter. Why you have not submitted, you know?
No, performance guarantee has to be submitted by them. They have said that we are accepting that, but after accepting for execution of the contract, they have to take some steps that they have not taken.
So have you initiated any proceeding against them?
No, Malab.
You have not, that is not the ground of cancellation of the tender.
Correct. That is not the ground of cancellation. Malab, kindly see the rate, Malab, page 9. Page 9, Malab, this is just a comparison, the
Page 9 of your affidavit.
page 9 of the affidavit 166, running page is 166, otherwise internal page is 9.
Hmm.
But the rates which are very important, Malab, here, the financial year 2014-15, 1 liter liquid nitrogen, that it was the approved rate at that point of time is 14.55. The Premier Cryogenic Limited, this is a petitioner, they were the approved supplier at that point of time. 15-16, it has become 15-30. Then, Malad, 16-17, NRL Numoligar, they were given, the rate came down to 8 rupees. Then, Malad, 17-18, 8.75, then petitioner again, NRL did not compete, Malad, petitioner again, they came down from 14.55 to came down to 8.75. Then in 18-19, 7.90. Then in 19-20, they have increased, Malad, 9.30. Then 2021, 9.50, 2021-22, 9.95. And Malad, in this tender, which has been cancelled, Malad, now the rate has come down to 7.25. And the petitioner has quoted in this process 9.75. This was not been acceptable, and at 7.25 they have been given the 4 lakh liter. So that is the price is the criteria, Malad. And as regard the relaxation of clauses, Malad, in the JAM portal, a registered contractor can only take part in a tender process. Malad,
Well, that part we are not
Lordship,
going into. That part we are not.
So
going
price is the criteria. Price is the criteria. Only the financial involvement is the criteria. In fact, in our affidavit, Malad, in this paragraph, we have narrated, Malad, ultimately the cost of the at page. If Lordship kindly comes to page 8, Malad, in the affidavit, Malad, we have indicated, Malad. The cost of liquid nitrogen forms the major chunk of expenditure in the system of supply of liquid nitrogen at higher rate may lead to upward variation of the cost of the end product, and it will be an additional burden on the farmers. The cost of frozen cement straws dosage is fixed by the governing body of ALDA. Considering all the above from time to time, the last revision took place in the year 2015, and the cost of frozen cement straw dose is rupees 50 at the farmer's doorstep. So ultimately, if they have to if they incur more money for having the liquid nitrogen is the lifeline for the entire project, what they are doing. So ultimately, the cost, the end user have to bear the more cost. So they want to take it down.
That's all.
That's all. So the decision making process, Lordship, the records.
Where is the record?
Yes, sir, I have not.
Show me the decision which led to the impugned order of cancellation.
Yes, sir.
Please flag back it, Mr. Nath.
The appellate authority order they received on 6th of January. After receipt of the order, they have taken the steps. Note sheet reveals not. I have flagged my blood. Pink flag.
All right. Mr. Chaudhary, just before Mr. Datta argues, why the petitioner did not challenge the award of 4 lakh liters even while filing this writ petition?
But we were all along under the impression, this is the stand. If your lordship will kindly allow me to place one position, page 244 of the pleadings.
Just mention why it was not challenged.
Because they gave us at the lowest rate, which was not our rate. Our rate was slightly higher. We accepted that. 4 lakh liters we accepted. And we said that we felt that these 4 lakh liters we are under the law, as per the law, we are entitled. And the remaining 8 lakhs, the manner in which they have sought to cancel the tender, we were bona fide under the impression that we will. There was to that extent, that technical aspect remains. But the statement that
no, it's a very important technical aspect. Unless this is set aside, there can't be a mandamus to award
the difficulty was, my lord, because we had already accepted the rate given in that.
See, otherwise your client probably had a good case on this. That if you L2 bidder, he might be, but the work was given at the rate of L1 bidder. Work was given at the rate of L1 bidder. There was no mention that the work will be split. So therefore, you had to give it to one party and for the entire quantity. That's an acceptable argument. But that aspect of the matter, the court cannot.
At that time, my lord, yes, there was.
But anyway, I just wanted to know if there is any other.
But the fact that we were willing is a pleaded position.
But that is not under challenge.
I appreciate.
Mr.
That
Datta,
challenge is not there.
You see, it will be a pleasure to hear your argument, and the court is willing to hear you as long as you want to argue. But before you start, please consider one aspect. At the moment, as I have indicated, the court is not inclined to go into the fresh NIT aspect. The court is not inclined to. The cancellation of your client's bid has attained finality. You can't get any relief here. So if you argue at length on the other part of the matter, then the court will have to deal with it. Whether it will be a good idea for your client at this stage or you want to reserve it, because there will, in all probability, a second round in the matter. That is a call you have to take. But if you argue, we'll deal with it. Then we'll have to go deep into the matter.
Lord, having participated in the bid,
Hmm.
my lord, whether my learned friend can challenge the new bid which
You
was.
bid, I am not entertaining the challenge. I said it. You're not.
And,
not,
and the
uh,
reason is, my lord, your lordship can.
No, I'm
appreciate-
saying, please, in an open mind, please understand and appreciate what I'm saying. Challenge to the new tender will not be entertained in this petition, but we will, the court doesn't want to give any finding. Just wants to leave it open for an appropriate
Lord,
time.
if your lordship not, my lord, accepting whatever.
We'll
challenge
note
they
his
have made,
argument and we'll say that we are keeping it open, giving liberty to petitioner. And the private respondent has also not advanced any argument in view of the above. Both parties will be at liberty to take their legally permissible stand in the matter as and when the occasion arises. This is one option. If you argue at length, then of course Mr. Chaudhary will have to be also given an opportunity to deal if he has to make any further submission. On the new NIT in the James portal,
Right.
he said that this completely does away with the, this is done away with the eligibility norms altogether. And the whole purpose is to accommodate you.
Lord,
Correct.
that I can justify, it is not.
No, but
Lord, anyway, if your lordship is
you want
not
to do it
entertaining,
right now.
no, if your lordship is not entertaining the new bid which is in challenge, your lordship is not entertaining, then I'm not required to make any argument to that.
That's why I'm saying. Other things you have nothing to submit.
My lord. Other is, my lord, what my learned friend has challenged, these are all imaginary grievances that I
Then
cannot
you are
supply.
arguing, then if you are
No.
arguing, then he will
No,
reply.
no, I'm not going to that at all. So since your lordship has very freely said that, I think it is not
But
required.
please be very sure, I am willing to hear you. If you want to argue, you address argument. In that case, I'll have to deal with it.
No, that's, I
I'll have to
understand.
deal with it. Arguments made at the bar will have to be dealt with it.
No, but since your lordship has said very freely that your lordship is not entertaining.
Not interfering with the new tender, but
Yes.
leaving it open.
that,
And the
that's
reason
okay.
for not interfering is that at the moment it is just bid floated in the gems. Whether it is done with a view to favor any bidder or not, that will be apparent only after the tenders are opened and a decision is taken to finalize it. So at that stage, we leave the parties to assay it, both parties, and take any plea
No,
that they want.
tender has already been opened, even financial bid also been opened, my lord.
But they have not decided whether they'll go ahead with it.
Okay, let them, my lord, finalize the entire deal.
There is an interim protection.
The weather can change anytime. Today you are sitting in a good position, you may not be
My
tomorrow.
lord, there is just.
Tomorrow you may be the one challenging the tender for all you know.
Lord, at this stage, I can't say anything.
That's why you can't say. Weathers do keep changing, na? Climate changes.
Yes, yes, definitely.
So is it necessary to go into that aspect of the matter? today?
I think it is not necessary. At this stage, it's not
There's
necessary.
only one thing your lordship will verify from the government. They have proceeded with the tender as if it is for the entire 12 lakhs. If, I don't know whether they have opened the financial bids, what is the position? I just overheard my learned friend saying, even the financial bids have been opened.
We will make it clear that you can't disturb his 4 lakh liters. If you want to argue on that, you are free to argue.
Lord, since everything is clear to me,
4 lakh liters
I-
cannot be just by a stroke of pen, you cannot take away. You have not heard him, no notice supplied, nothing, no. It has created a right in favor of the petitioner. You have awarded the contract.
my lord, it's up to your lord, yes, my lord. I don't think I can say anything on that.
That's why I'm saying, right now, if you open up, then it could be problematic for any of
Yes, yes, yes.
They will also be now more cautious. And if you argue now, then
No, for me, it is not
It
necessary.
is not good for your client.
Yes.
If he argues further, it may not be good for his client. But Mr. Nath, things are not sending a good message. You are as a lawyer, you are entitled to argue your brief.
Gotcha.
And they are also. And that we appreciate. But what is happening is clearly showing what is happening.
Well, considering the.
We will take care of that in a suitable manner. We'll tell in the judgment that this court is not at all approving what is happening. It is just that we refrain from making any comment at this stage by giving complete liberty to parties to raise the issue, approach the court once again, raise all legal issues, and if it is raised, it will be looked into by the court. That much of observations will be there in the judgment.
But that's correct. But I can place from the records whatever they have done. But my submission is that there is no malafide or arbitrary, whatever they have done, they have considered the peculiar facts.
The
of the case.
malafide is writ large on the face
No,
of the record.
No, in my respectful
Now,
submission.
how could you split it 12 lakhs, 8 lakhs and 4 lakhs?
It is the decision of the committee.
That decision is wrong and arbitrary. That is only because there is a driving force behind it.
But that is the.
They will not take this
If it is
decision.
arbitrary, then it is arbitrary for the private.
Your
respondent.
own secretary has held it's arbitrary.
So, if it is arbitrary, then this arbitrary action has been taken.
Mr. Datta has
again-
accepted that the decision is arbitrary. He has accepted it, it's arbitrary.
Against the.
Your departmental secretary says it's arbitrary, the beneficiary has accepted, the department has accepted, the
this-
lawyer is not accepting.
Well, secretary has said that the technical responsive, the decision of technically responsive, the bid of the respondent number 6, that is not correct. That is the decision. Secretary has not said that the award and all these things. They have said that the technical responsive decision as regard the responsiveness of the technical bid, that is not correct.
So that doesn't mean the process is unfair and arbitrary.
Well, in fact, the final.
Mr.
decision-
Nath, you need to look into some of the literature on that. Secretary is not the judicial authority that will deal with every aspect. Once somebody's non-responsive bid has been accepted and the secretary says it's wrong, that means the process is fraught with arbitrariness and illegality. That position has been accepted by everyone. The tenderer, the department, everybody has accepted. You cannot now say anything contrary to that. You have to say that, yes, we have done it in an arbitrary manner. Now this is what we are proposing it. That is the only argument you can make before the court. No other argument you can make. You have accepted it. There is no challenge to this.
The authority.
Yes,
Appellate
this,
authority
the
is already
decision of the appellate authority has not even been judicially tested, which means what?
Nobody has.
There was no grievance.
Correct.
Nobody had any grievance against the finding of the statutory.
Well, in fact, the authority, tendering authority has also accepted the appellate authority's order, and subsequent actions have been taken.
Yeah,
That is that there
and,
is
and now the reasons why the bid was found to be non-responsive, now it has been made responsive by removing the criteria. That's his argument. So earlier, these were the criteria, this was his eligibility. It did not match, he did not meet. So accept it and now remove the criteria itself so that next time there is no ground of non-responsiveness. That is what is sum and substance of his argument.
Since Lordship is not entering into the second, the retender aspect. Otherwise, what they have projected, that is a tailor-made. Tailor-made to remove somebody from participating.
only
That
reason-
is-
only
that
reason
not the
is,
case.
Mr.
And
Nath,
the-
Please listen. See, these tailor-made arguments, Mr. Chaudhary has relied on a judgment. There are other judgments, 1 or 2, which says when it is done to eliminate, then it is restrictive and violative of the rights of other bidders
Yes.
who have been precluded.
Yes.
But there is no judgment which says tailor-made tender conditions should be interfered with because it widens the scope. There is no such judgment. And
Well,
that's not, listen. It will help you in another case.
Lordship.
I have told you what order I am passing here. You can't change it.
Correct.
But listen to this, it will help you in some other case.
Lordship.
But even if it is widened, correct. Even then, once the authorities take a decision, now they have not taken a decision. That's why the court doesn't want to go into it. Once they take a decision, that will be subject to judicial review. And at that stage, we'll see in what manner Article 14 comes into play. So by not entertaining it, because at the moment the court will either preclude or preempt, but they will take a decision to award it to Mr. Datta's client. Right. And at that stage, this aspect of the matter will be again live, active, and completely inviting to the courts to
Correct.
access it. Now, if you means not you individually, your clients, do it in such blatant manner. All right, last time we wanted to give you, you are not eligible. This time we'll take out the whole work and give you by making you eligible, because there will be no restrictive condition at all. Think about the consequences. Tell your clients to know the consequences of that. Of course, because of judicial propriety, we will not go into that aspect of the matter today. So and so reserve, order reserve. Is there a stay order here?
Yes, but there is an injunction.
Not to finalize.
Not to finalize.
All right. So we'll try to deliver the order by next week. By Tuesday, Wednesday next week. Mr. Nath, I'm keeping the record. I'll give it to you.
Deeply obliged.
Yes, what is the matter?
My lord, the petitioners, my lord, they are claiming that the certain, my lord, reserve category candidates, although they were meritorious, my lord, they have been kept under the reserve category, meaning thereby, my lord, depriving his right to be appointed. My lord, the petitioner is an OBC, OBC candidate, my lord. My lord, our reply in the affidavit is that, my lord, the cutoff marks has not been met by the petitioner. Even
What
under,
is the cutoff mark?
my lord, in the affidavit, my lord, I have stated, my lord. My lord, the petitioner has obtained 43 marks. Whereas, my lord, will see paragraph 12 of my affidavit in opposition. Paragraph 12, my lord.
Just one minute. Just 1 minute. Where is Mr. This is what R. Majumdar?
My lord, he was on legs, my lord, he informed me that, my lord,
Achha, just 1 minute.
my lord.
Please take your seat. Let me
Yes.
go through the record. So one post has been kept vacant.
My lord.
Now, he belongs to petitioner, belongs to OBC, right?
OBC, my lord.
What is the mark he has, what is the marks he has?
My lord, he has secured 43.
Hmm.
And my lord, he has availed the category relaxation. And my lord, under the office memorandum, my lord, clearly provides that once a
1
candidate.
minute, 1 minute.
My lord.
The last selected OBC candidate, what did he score?
My lord, he scored, my lord, the petitioner has applied in the three forces, my lord, BSF, CISF and CRPF.
Hmm.
So, my lord, in BSF, the last OBC candidate, my lord, secured 52 marks.
Hmm.
And in CISF, it is 49, my lord. and CRPF it is 50. So in all the three categories, my lord, he is below the cutoff marks.
Okay, and where have you stated this? Is there any affidavit?
Yes, my lord, paragraph 12 of the affidavit in opposition, my lord. My lord, by way of a chart, my lord, we have specified two categories, my lord. That is, one is the marks of last selected OBC candidate, and the second is, my lord, is unreserved candidates.
And where have you mentioned that the petitioner is code 43?
My lord, 12.2, my lord, at the tabulation below, my lord, 12.2. From the above table, it is very clear that the petitioner who has obtained only 43 marks could not be recommended for appointment against any of the forces, let alone the CPFs opted by him.
Yes, Mr. Majumdar, you are appearing.
My lord, yes. Here the petitioner's initial case was that persons the reserve category candidates who had scored more than the unreserved category candidates were retained back in the reserve list, and therefore he could not make it to the cutoff marks. We had relied upon the case of Jitendra Singh as decided by the Supreme Court to say that taking an advantage, taking a relaxation either on the age or other parts, other qualification, other criteria would not be taking a advantage on merit, and therefore they would only come on the level playing field. If only on merit they fail, then they go to the reserve category. But that has been somewhat differentiated by the DIPA EV case of the Supreme Court itself. I have gone through the advertisement and everything. In the advertisement, there was a clause that if someone takes a relaxation, he will not go to the unreserved category, he remains in the reserve category. Unfortunately,
But
not challenged.
what do you say on para 12? That punches a hole on your case, no? Para 12 of counter affidavit.
Yes, my lord.
All the OBC candidates have scored.
That is what my lord. If those candidates, Lordship will see, and the BSF itself, the cutoff is 52. Lordship, if comes to the other side, the general cutoff is 52. Now, any OBC person who had scored 50 should have gone into the.
Your client has applied for three categories, three forces,
Three
BSF,
forces.
CISF and CRP.
CISF, CRPF. Yes. Now, CISF, if Lordship finds the last candidate scoring is 49. Unreserved category was 50. Now, a person, a CISF, OBC category candidate who had secured 48 marks should have gone into the unreserved list.
Who is that person?
But that I will not be able to identify, that they have to identify.
That will be very
Otherwise, also, Madam, that is what I was saying. Madam, if Lordship will kindly have, I have a very bad case, Madam, I admit. If Lordship will have a page 5
And you
paragraph.
have it in your hand for next 2 minutes only.
Madam, yes. No, I have a bad.
No, Mr. That is too speculative. You feel that some people scored more marks, they should have been moved as general category.
My lord, they have.
Because there is a clause in the advertisement.
No, the clause in the advertisement goes against me. And I have not challenged this, is what I'm trying
You
to
have
say.
not challenged
Had I challenged it, I would have had a good case on Jitendra Singh. I do not challenge it, and therefore DIPA EB will cover me.
That's it. Where is the advertisement?
My lord, the advertisement in the writ petition, Lordship will find from page 15 onwards.
Page 22 is the, my lord.
And page 22 is that clause, my lord, which goes against me. Page 22, clause 10. Clause 10, Lordship, has the proviso. Provided that SC, ST, and OBC who are selected on their own merit without relaxed standards along with the candidates belonging to their communities will not be adjusted against the reserve share. Such SC, ST, and OBC will be accommodated against the general unreserved vacancies as per their position in the overall merit list. Reserve vacancies will be filled up separately from eligible SC, ST, OBCs candidates, which thus comprise of SC, ST, OBC candidates who were lower in merit than the last general candidate on merit list of unreserved category, but otherwise found suitable for appointment by relaxed standards. So anyone who takes a relaxed standard stays in the reserve list, is what this clause says.
So this is not under, clause
now-
10 of the advertisement is not under challenge.
So this clause having not been challenged, my entire petition would fail because that very ground that they should have migrated is forbidden by this clause. I had this clause in
So
hand.
your case is
participated.
that the reserve category candidates who have scored higher marks
My lord,
and were otherwise entitled to be appointed on their merit position should have been migrated to the unreserved list, in which event there would have been more space in the reserve category, and then your client would have made it.
yes,
But that position is cut short by clause 10.
by this clause.
And secondly, according to them, your client scored less marks than all the other categories of
Those who have
reserve
been selected
category.
and appointed,
OBC.
appointed.
So from both perspectives,
Even my lord, in 2018.
you don't have the freedom to argue by relying on the decision of Jitendra Kumar Singh.
Yes, this,
That's
this
the-
clause will take it away. Had I challenged this clause in this writ petition, perhaps saying that it is against the Jitendra Singh's judgment, my lord, this clause could have been challenged. This cannot stand.
So you don't want to challenge it now.
My lord, that I'll have to file a fresh petition, I'll have come and back with an amendment.
Yeah.
Lordship allows me, perhaps I can have a.
No,
discussion
let him
with the-
be at peace now, and that would also be a too speculative an argument at this stage. So it's better we
In the
close it.
presence of this clause, even in Gaurav Pradhan, my lord, the Honorable Supreme Court has said that they should not have been allowed to migrate in the presence of this clause or if there is an office memorandum standing. And again, Supreme Court has
So
said
now,
not challenge.
how can they migrate? It will completely upset the entire.
And enter selectly should be. That is the.
So we'll close it, Mr. Majumdar. You take down, heard Mr. R. Majumdar and counsel appearing for the writ petitioner, also heard Mr. H. Gupta and Ms. CGC appearing for the respondents. In response to the advertisement notice dated 15/12/2012 issued by the Staff Selection Commission inviting applications for recruitment of constables, bracket GD, bracket close, in the Central Armed Police Forces, bracket CAPF, bracket close, and riflemen, bracket GD, bracket close, in the Assam Rifles. The petitioner, who belongs to the OBC category, had submitted his application and thereafter participated in the selection process. The writ petitioner had secured 43 marks but was not selected. Full stop. Aggrieved thereby, the petitioner has approached this court by filing the instant writ petition. Full stop. The basic case of the petitioner is that those candidates belonging to the reserve category who were otherwise eligible to be appointed on their general merit position was required to be migrated to the unreserved UR category, in which event the petitioner, even with 43 marks, would have made it as a selected candidate by virtue of his entitlement as a OBC category. Full stop. Such argument has been made by the petitioner by relying upon the decision in the case of Postgraduate Institute of Medical Education and Research versus K full stop L full stop Narasimhan, reported in 1997, bracket close, 6 SCC 283, and in the case of Jitendra Kumar Singh, JITENDRA, Jitendra Kumar Singh versus State of Uttar Pradesh, reported in 2010, bracket close, 3 SCC 113, full stop. By taking note of the petitioner's case, the learned single judge had passed order dated 6/4/2017, issuing notice upon the respondents, and in the interim, it was ordered that one post of constable bracket GD bracket close be kept vacant in the CAPF. Stop. On receipt of notice, the respondents have appeared and filed their counter affidavit. Full stop. From the averments made in the counter affidavit, it transpires that the petitioner had indeed scored 43 marks. However, the OBC category candidates who were appointed, the last selected OBC category candidate who were selected in the BSF, CISF and CRPF had scored 52, 49 and 50 marks respectively, thus scoring higher marks than the petitioner. Therefore, insofar as the OBC category of candidates is concerned, it is evident that the last selected candidate appointed in all the three police forces for which the petitioner had applied had scored higher marks than him. First stop. Insofar as the argument of migrating the UR candidates, migrating the reserve category candidates to the UR list is concerned, it is seen from the record that clause 10 of the advertisement notice dated 15/12/2012 prohibits such a migration. The relevant portion of clause 10 is reproduced herein below for ready reference. You'll get it in page 22. Yellow flag mark, page 22, double tick to double tick. The petitioner has not challenged the aforesaid clause 10 of the advertisement notice. Therefore, the decision in the case of Jitendra Kumar Singh Supra relied upon by petitioner would not have any relevance in the facts and circumstances of the case. Mr. Majumdar, learned counsel for the petitioner, has also fairly accepted the said position. If that be so, nothing further survives for adjudication in this writ petition. Consequently, this writ petition stands dismissed or disposed of as not maintainable in the eye of law. Interim order passed earlier stands vacated. So a short comfort.
We have filed by the state respondent also. First department. Petitioner's name was recommended by the SLC, but not yet appointed lordship.
Yes, who is appearing for the government?
Lordship, the first department.
Huh? We'll allow the petition with a mandamus to appoint him because there is no representation and there is no affidavit also filed. Where is the recommendation?
Lordship, at page 53.
Page?
Page number 53. Serial number 217. Name of the applicant, Nayanjoti Pekka, as general. Recommended for appointment against the vacancy of grade 3 post for the year 2010.
This is SLC recommendation.
Lordship.
All right, take down. Whose name should I record?
My name is,
Mr. NJ. Are you sure?
but I am on behalf of Mr. Jagwalda.
All right. He will not be annoyed with you.
Lordship.
100% sure.
Lordship.
Heard Mr. NJ Gogoi, learned counsel for the writ petitioner. Also heard Ms. M. Bhattacharjee, learned government advocate Assam, appearing for the respondent numbers. You have for respondent number?
2, Lordship.
Lordship, yes, for two, Lordship.
Appearing for the respondent number 2. None has appeared for the ESCO numbers 1 and 3, although the name of the Learned Standing Council Forest Department has been duly shown in the call list. First of all. The petitioner's father died in harness
19/6/2008.
on 19/6/2008 while serving as
Foresta Grade 1.
this is Baksa.
Baksal. Under Mosolpur.
So then SC-BTC is required. Oh, BTC is not a party here.
No, Lordship,
is
they
not
have
a-
written in Kamrup district. Then,
No, unless BTC is there, this order, they will come for review. We can't pass this.
May I submit one thing?
Hmm.
Lordship, the thing is that this, regarding compensation upon under Forest Department Lordship, there was no DLC Lordship prior to Lordship 2016.
Hmm.
After 16, new notification has come and it has DLC has been placed. So before 2016, since there was no DLC, it was directly placed to before SLC.
Hmm.
SLC is the PCCB is the Lordship authority.
But where is the post?
Post Lordship,
Hmm.
thing is that Lordship since 1992 Lordship up to 2015, and no appointment and compensation governed under Forest Department was made.
You are not
Yes.
answering my question. Where is the post against which your client will be appointed?
Post Lordship.
Yes,
Post Lordship I have not shown because
then we cannot pass any order.
Lost.
You call the Forest Department council.
Lordship.
Call him. You wait for some, you call him. If it is in BTC, then you have to implement BTC. They're as simple as that. There cannot be appointment in thin air. Which is that post against which the,
Forest Department comes.
call him,
Lordship.
call him, tell him to come. Yes, what is?
May, my lord, regarding my dismissal from the service, my lord. My lord, I have been appointed to the post of the constable by the respondents, my lord. Subsequently on 10/1/2019,
Hmm.
I obtained the leave for 1 month, my lord. And after obtaining the leave, my lord, on the expiry of the leave period, I did not attend the office, my lord. As my mother was ill, she was suffering from liver cancer, my lord. And accordingly, I was busy in treatment. Consequently, I could not give the reply, even though the notice was received at my home in my absence. And that was the reason that I was removed, my lord, from the service, my lord. The impugned order you will also will find at page 23. Annexure D, my lord. Sorry, my lord. Page 26, my lord.
Annexure?
Annexure E. Sorry, my lord. Annexure G, my lord.
No, you make up your mind. You are saying G, then E,
Sorry,
then
my
again G. So what
Sorry.
is it?
Sorry, my lord. At page 26, my lord. Annexure E.
Yes.
And this order was passed on 17/6/2019, my lord. May I read it, my lord? Whereas register number such and such, Viraj Singh son and such estate is already staying after expiry of sanction leave with effect from 10/2/19 without prior permission of the competent authority. That whereas communication directing you to assume your duties was issued at your home address by memo number such and subsequent reminder letter such and such, but you fail to assume your duties. And whereas the court of inquiry was ordered, there is such and such, there is absence without leave as per provisions contained section 74(1) of such and such. And whereas on receipt of COI report, I, the undersigned, after having satisfied the opinion of the CIO, made a record there under justifying your absence without leave, an inventory of government property in your possession copy of the court of inquiry is enclosed, even though it was not supplied to me, my lord. And whereas apprehension roll was issued to concerned police authority to apprehend you, while letter number such as there is a reminder by there is a, and whereas when neither you have surrendered yourself either before the police authority or the unit, nor you were apprehended by the concerned police, you were declared as a disaster. Order number such and such, there is as per provisions contained section 74(2) of the copy of order discharging you deserted is included. And whereas a so-called notice was served upon you by such and such, such and such, such and such, with the direction to resume your duty within 15 days of the notice at office of the commandant 15 such and such, telling which you shall be dismissed from the service without any prior intimation, but you fail to assume your duties till date. And whereas second so-called notice was published on such an Dainik Jagran, local newspaper Gorakhpur, with the direction to resume your duties within 15 days of notice, but you fail to assume your duties till date. Copy of so-called notice published in newspaper is enclosed. Now therefore, in accordance with the power conferred upon the undersigned as per Rule 21 read with Rule 18 of such an, you are hereby dismissed from service with immediate effect and also struck off from the state in such and such. My lord, this is the notice, my lord. Now, my lord, I submitted the representation, my lord, that your lordship will find. I have annexed the documents, medical report and other things, my lord, so far my mother is concerned. And those your lordship will see annexed from B onward, my lord. Page 23, my lord. 22, 23, my lord. Homi Baba Central Hospital, my lord. This was dated 12/1/2019, my lord. Next one, my lord, 2/2/2019, my lord. The next one, my lord, the All India Institute of Medical Science, Jodhpur, my lord, dated 25/10/2017, and other documents, my lord. Now, my lord, I also filed the representation before the authority that your lordship will find at page 47, my lord. This is the appeal as well as the representation. This is the appeal which I filed, my lord. Page 47, and it was filed on 12/7/2019 to the appellate authority, my lord. In this particular case, the Inspector General is the appellate authority, my lord. This appeal I filed as the appeal is provided under Rule my lord 29 of the rules, my lord. I filed the appeal in which I have narrated all the sequence, my lord, why I could not attend it, my lord. May I read it, my lord? There are two. That I applicant on 8/1/19 had gone home on leave for 1 month from such and such for treatment of my mother, who is suffering from cancer, and present her treatment is carried on at Homi Baba Cancer Hospital, Banarsi, which is under the control of Tata Memorial Center. The copy thereof are included at page number such and such. That's all. Before my visit at home, such and such, my sister, Sanel Lata, took my mother to SBCS Banarsi, where the treatment was undergoing due to deteriorating health condition. Just after 2 days of my visit on my being worsened condition, she was under treatment in ICU. The copy thereof I enclosed number such and such. That after the discharge of my mother of the applicant from such and such Banarsi on such and such again on such and such, she was called for review by the doctors, and lastly on 13th she was transferred to Tata Memorial Hospital, Bombay. The copy thereof I enclosed at page number such and such. That's all. I, the applicant, along with my elder sister, took my mother to such and such Bombay for further treatment, where she was under continuous treatment from 8/2/2019 to 5/4/2019. During this period, RFA operation of liver, boiling and various tests and treatments were conducted. Again, the doctors of Bombay or such and such, referred her to HBC Banarsi for further treatment. The copies thereof are enclosed such and such. That's sir, I, the applicant, took my mother to such and Banarsi from Bombay, where the gap of 10 days is she undergone for chemotherapy. The copies thereof are enclosed page number 7. Sir, after completion of the chemotherapy on such and such, my mother was again referred to TMC Hospital, Bombay for consultation by Sir Banarsi. I, the applicant, along with my eldest sister, took my mother on such and such to such and Bombay and consulted the doctors who, after various tests, advised for further chemotherapy and referred the same to such and Banarsi. Copies thereof are enclosed at page number such and such. Sir, I, the applicant, along with my mother, went back to Banarsi for treatment, where from such and such after gap of East 10 days, chemotherapy was given after admission for 3 days. Total 6 numbers of chemotherapy was planned by the doctors of same Bombay, and again I was called to same Bombay for review. The copies thereof are enclosed at page number such and such. That's the chemotherapy of my mother was undergone at such and Banarsi after the gap of every 10 days. But after third chemotherapy on such and the condition of my mother became very serious on such and such, and she was immediately admitted to the Cancer Hospital, Gorakhpur for treatment. But since there was no improvement on such and such, she was admitted to Banarsi for treatment, and on improvement in condition, she was discharged on such and called on such and such for review. The copies thereof are enclosed herewith. That's at present, I am the applicant along with my elder sister took my ailing mother for treatment at such and Banarsi regularly, and when the condition became serious, he was admitted for 7-10 days and the treatment is regularly going. The copy thereof is enclosed herewith. That's sir, my old father is a heart patient, and after the operational treatment at AIMS Jodhpur, at present his treatment is going on under the supervision of different doctors at Gorakhpur. The copies thereof are next year too. That's sir, on such and such, I, the applicant, asked the doctors when time treatment of chemotherapy will be continued. They then replied the chemotherapy would be continued regularly till the medicine of Summer gave response. That's sir, we are 3 brothers and 4 sisters. But due to heavy expenses on treatment of my mother and father and disturbances, my 2 brothers are living separately with their wives and children, and the responsibility of mother and father is on me and my sisters. In this situation, I'm slowly dependent on my sister for looking after my mother, father, and I have appeared before you for appeal for giving bold responsibility for looking after and for treatment of my elder sister. That's sir, after completion of my leave, I, the applicant, tried to send fax to inform about my situation to my senior officers. After taking to the control room and DC Talwar over telephone in the month of February, they refused accept by saying that no fax for leave of any person would be entertained as per order of the commandant. Thus, sir, I, the applicant, being a very stressed mental condition, sent a reply application that is such and such in response to the department notice such and such, but my reply application was sent back at my address without going through the same. The copy thereof is enclosed page number such and such. That's why the notices were sent again and again by the department on the address to my native place, but I, being away to Bombay, Banarsi and Gorakhpur, could not receive the same in time, but received late, and being busy in the treatment of mother and father and family disputes, I was in mental stress, and for this reason I could not reply in time to the department, and I beg apology for the same. Thus, sir, I, the applicant of such went home on leave for 1 month for treatment of my ailing mother and father. Before my reaching on such, my mother was admitted to such Banarsi for treatment, which is evident from the statement in paragraph 2 and 3 herein above, and documents enclosed herewith. That on the basis of the documents, if evaluation is made, then it can be concluded that after getting leave from such and such, I was busy in treatment of and looking after my mother and father. This is my essential duty being son. That's without considering my position, without hearing me, passing or dismissal order. That is the appeal memo. That appeal was filed by me with these grounds. The appeal was also dismissed. And the dismissal, the lordship will find the next page, my lord. That is Page 39, my lord. Dismissal.
When was he appointed?
I was appointed, my lord, on 22/7/2006. Now, my
Acha, 1 minute, Ms. Sharma, you see, there is only one aspect which is striking this court. It's all right. He's been out without proper authorization, etc. These are all okay. We don't intend to interfere with the findings that he is guilty of some misconduct. But he has given in details the reason why he could not come. Mother's treatment, mother was suffering from cancer, father was undergoing, and they had to frequently travel to Bombay and Varanasi. So the only thing we are thinking is, can a lesser punishment be imposed upon him? So that at least he gets some pension or something, if not reinstated. Can you assist the court in that as a court officer? Not what other punishment can be considered? Supposing, see, there can be reasons, but that reason doesn't mean somebody can get away with. But only thing is the punishment of dismissal appears to be too harsh in the and disproportionate in the facts. That's the only thing the court is looking at. Will you be able to tell us rest of the things I have seen? Nobody, you are not denying that his mother, this is not a disputed question of fact that the mother was undergoing liver transplant, liver cancer,
Lordship.
treatment in Bombay. These kind of diseases do create a havoc. So there is nothing to disbelieve that he was trying to help his mother. So a balanced approach is what the court is thinking. Can you obtain that instruction? We are not asking for the
Lordship,
permission of the
Lordship,
authorities. But these matters, a little collaborative approach. Of course, he is yet to argue, but then I could see through what is there.
Lordship.
The punishment, difficult to accept.
Otherwise, Lordship, if Lordship goes to the case record, Lordship will find that ample opportunities we have given, whatever opportunities.
That is right. That's why
Yes,
his misconduct is not condoned.
Lordship.
You have not heard
Yes,
what
yes,
I
yes.
say. His misconduct is not condoned because he was attending to his ailing mother. That doesn't
Yes.
mean he can do
So-
and get away with whatever.
So whether his absence is willful or not, perhaps Lordship is
That's the
wants
point.
to
So to that extent, if the punishment of dismissal is too harsh,
Lordship.
prima facie the court
Lordship.
feels so.
I have to
So
take,
if you can come up with a suggestion, we can ask Mr. Bhatti also. Otherwise, we'll either dismiss the petition or reinstate him.
that instruction, a written instruction I have to take, Lordship. Whether any lesser punishment or they may rethink about his application.
Later open.
We can't completely condone because there are, they will, the
My lord,
discipline,
otherwise I may.
disciplinary
satisfy your
force
lordship.
is also
Let-
required.
Let her obtain the instruction, my.
Huh?
Let her obtain the instruction.
Hmm.
That is a different
The
thing.
court
but
is not
otherwise I-
inclined to send you back to the force.
Otherwise, I may satisfy your lordship. Your lordship may not agree, but I may set, I will try to satisfy your lordship that I have a case.
All right.
But he himself in his later dated also admitted that
All right,
after
you argue, we'll pass a judgment. You are not understanding what I am saying. You argue, we'll pass a judgment on merit.
My lord, this is the appeal.
Hmm.
I filed and this appeal was disposed of and that is at page 39, my lord.
Page 39.
Yes, my lord. And how this appeal has been read. My lord, it starts, my lord. And my lord, there are 2, 3, 4, 5. They are the repetition of the dismissal order, my lord. Now, my lord, your lordship will come directly at page 42. The earlier statement made in the order, my lord, those are the repetition of the dismissal order, my lord. Your lordship may come directly to page 42, my lord. Second para, my lord. Therefore, have you got it, my lord?
Yes, yes.
Therefore, after going through the contents of the appeal, that is such.
Page 44.
Page 42.
Yes.
Therefore, after going through the contents of the appeal, that is such and such in the light of document forwarded by the Commandant 15 Kokraja undersigned being appellate notice, considering the entirety of the case, is the opinion that the Commandant being the disciplinary authority has followed the laid down procedure as per SSB Act and rules, and individual was given ample opportunity to resume his duties prior to issuance of dismissal order, to which individual failed to respond. Hence, the decision of Commandant regarding punishment dismissal of service, that is only the ground, my lord. Nowhere, my lord, the grounds which I have taken in my memo copy, as your lordship has already gone through the grounds which I have taken, none of the grounds has been considered in this particular case.
So you want the order, appellate order to pass a fresh order?
This order after giving me the, and this order was passed without giving me an opportunity, my lord.
How without giving you an opportunity? You are not heard.
No. I was not heard, and no ground has been, the grounds which I have taken in my appeal memo, those have not been considered. Now, my lord, apart from it, my lord, may I take your lordship to certain provisions of the
Is
Act
it correct that his grounds have not been discussed?
Lordship, page 41, Lordship, prior to this decision, Lordship,
We asked the appellate authority to pass a fresh order after
much of that.
applying mine on the,
Lordship.
Yes.
yes, take down. Heard Mr. O.P. Bhatil and a counsel appearing for the petitioner, also heard Ms. B. Sharma and CGC appearing on behalf of the respondents. The writ petitioner herein joined the Sasastra Sima Bal bracket SSB as a constable bracket general duty bracket close on 22/7/2006 and was posted at the 22nd Battalion of the SSB at Ranidanga, RANIDANGA, full stop. After serving at various places, the petitioner was posted under the 15th Battalion of the SSB at Kajalgaon in the district of Chirang on 19/6/2017. Full stop. While serving at Kajalgaon, the petitioner had applied for 31 days earned leave with effect from 10/1/2019 to 09/02/2019, along with permission to avail suffix on 10/2/2019 for medical treatment of his ailing mother, who at the relevant point of time was suffering from liver cancer and was residing at the native place of the petitioner at Uttar Pradesh. The leave application of the petitioner was sanctioned, and accordingly, the petitioner proceeded on earned leave. However, after the completion of the leave period, the petitioner could not join back in duty. Full stop. As per the case projected in the writ petition, the petitioner had to take his mother for treatment at the Homi Bhabha, HOMI BHA Cancer Hospital at Varanasi on 07/01/2019. No, 07. No. As per the case projected in the writ petition, the mother of the petitioner had to be admitted at the Homi Bhabha Cancer Hospital, Varanasi on 7/1/2019 by the family members of the petitioner. And though she was subsequently discharged from hospital, yet on several occasions she had to be readmitted and presented before the doctors for review of the treatment. Not only that, the petitioner's case is also to the effect that he, with the assistance of his elder sister, had to take his mother to the what is this hospital in Mumbai? Tata Memorial Hospital at Mumbai from time to time for the treatment of his mother. Full stop. Around the same time, the father of the petitioner, who was also a heart patient and was suffering from old age ailments, had to be looked after, as a result of which the entire family was in distress. Full stop. The petitioner has admitted that notices sent by the employer before issuing the order of dismissal dated 17/6/2019 had been received in his village address, but since at the relevant point of time, the petitioner was frequently traveling to Varanasi and Mumbai and was also under serious mental exertion due to the ailment suffered by his mother. He could not respond to the letters, notices issued by the authorities, as a result of which the petitioner was declared as a deserter, within the meaning of Section 74 of the Sashastra Seema Bal Act, 2007. Subsequently, the impugned order dated 17/6/2019 dismissing the petitioner from service was issued by the commandant of 15 Battalion, SSB at Kajalgaon, that is the respond number 5, full stop. The petitioner had preferred an appeal against the order of dismissal by narrating the factual background and the circumstances under which he had failed to either join back in service on expiry of the leave period or to respond to the notices sent by the department. However, the appellate authority had rejected the appeal and had affirmed the order of dismissal from service by issuing the order dated 18/11/2019. Full stop. Mr. Bhatti, learned counsel for the petitioner, submits that the order of dismissal from service in the facts and circumstances of the case is shockingly disproportionate, since it is not a case where the petitioner was negligent in returning back to duty, but was unable to do so under compelling circumstances, as he was discharging his moral duties by trying to get physical comfort for his ailing mother. Full stop. However, according to Mr. Bhatti, the aforesaid aspect of the matter was not at all considered by the appellate authority on account of the fact that none of the grounds stated in the appeal memo filed by the petitioner was even considered, far less, dealt with by the authority in the appellate order dated 18/11/2019. Mr. Bhatti submits that the order dated 18/11/2019 has been issued in a most mechanical manner and has merely reiterated and oblique or reproduced the order passed by the disciplinary authority, that is the respond number 5, and therefore there was no proper exercise of jurisdiction in the matter by the appellate authority. On such ground, the learned counsel for the petitioner has prayed for setting aside the order of dismissal from service dated 17/6/2019, as well as the order passed by the appellate authority on 18/11/2019, by contending that the failure on the part of the appellate authority to exercise his statutory duty enjoined by appeal is under
Rule 29.
enjoined under Rule 29 of the
Sastra Sevabal Rules 2009.
rules of 2009. And therefore, the entire proceeding leading to dismissal of the petitioner is vitiated in the eye of law. First of all. Ms. B. Sharma, Planet CGC, on the other hand, submits that repeated attempts on the part of the authorities to serve notice upon the petitioner. Now, repeated attempts on the part of the authorities to secure the attendance of the petitioner on duty has not only ended in failure, but the petitioner has also failed to respond to the notices sent to him by the departmental authorities at his permanent address. Under the circumstances, the authorities had no option but to issue the order of dismissal from service, as otherwise the same would lead to anarchy and indiscipline in a force like that of the SSB. The learned CGC submits that the impugned order was passed on the basis of materials available on record. However, the learned CGC has fairly submitted that the order dated 18/11/2019 passed by the appellate authority does not clearly reflect as to in what manner the grounds taken by the petitioner in his appeal memo has been dealt with in this case. Where is the rule? Give me the rule. Rule 10.
Yes.
I have considered the, oh, give me Rule 10. Don't ask me to find out everything. I have considered the submissions advanced at the bar and have also gone through the materials available on record. There is no dispute about the fact that the on leave application submitted by the petitioner was granted by the authorities, pursuant whereto he had proceeded on leave, but the leave of the petitioner was sanctioned only till 9/2/2019. 9/2/2019, is it? After expiry of the leave, the petitioner had neither applied for extension of the leave, nor did he return back in duty. It is also the admitted position of fact that around that time, the mother of the petitioner was suffering from terminal illness, requiring him to take her for advanced treatment to Varanasi as well as Mumbai. And the father of the petitioner was also suffering from heart diseases. It is in such factual backdrop, it would be necessary to consider as to whether the disciplinary proceeding initiated by the petitioner, by the authorities against the petitioner by treating him as a deserter was justified in the facts and circumstances of the case, and if so, whether the order of dismissal from service was shockingly disproportionate to the facts and circumstances as well as the gravity of the misconduct. First up. Insofar as the first question is concerned, Section 10 of the Sashastra Sima Bal Act 2007 permits the authorities to impose the penalty of Section 10 read with Section 11, penalty of termination from service or dismissal in accordance with the provisions of the Act. First up. Where is the disciplinary proceeding? Where is the order, initial order? 17/6/2019. Where is that order?
Page 26, madam.
By invoking the jurisdiction under Rule 21, read with Rule 18 of the SSB Rules 2009, the respondent number 5 had issued the order of dismissal from service to the petitioner. Full stop. Full stop. If the petitioner was absent from duty after the expiry of his leave period, and nor did he submit any application for extension of leave or any information, no, nor did not, and you like it. The petitioner had neither submitted any application for extension of leave, nor did he inform the authorities as to the reason for which he was unable to join back in service. Under the circumstances, it was not only justified for the disciplinary authority to initiate the aforesaid proceeding against the petitioner, but such proceeding, according to the opinion of this court, was also initiated, leading to the issuance of the order of dismissal dated 17/6/2019 by following the due process of law. Full stop. What is, however, significant to note here in that when the order of dismissal from service dated 17/6/2019 was issued, the authorities were not, the disciplinary authority was not fully aware of the facts and circumstances, of the background facts and circumstances, as a result of which the petitioner had failed to join back in duty or to respond to the notices sent by the department. Such facts were, however, before the appellate authority, wherein the petitioner had narrated in details his circumstances in his memorandum of appeal. Full stop. If not for deciding as to whether the proceeding initiated against the petitioner was justified in law, at least for considering whether the penalty of dismissal from service was justified or whether the same was shockingly disproportionate to the gravity of misconduct, is a matter which ought to have fallen for consideration before the statutory authority. But, full stop, but from a perusal of the order dated 18/11/2019, this court finds that there was no such consideration made by the appellate authority with regard to the explanation submitted by the petitioner for failure on his part to report back to duty. Full stop. Under the circumstance, then what is Rule 10? You said Rule 10, appellate authority's power?
Appellate authority's power, my lord, is
20 and
29.
Next para.
Rule
Rule
29.
29 of the SSB Rules 2009. Rule 29 bracket 3 of the SSB Rules 2009 not only empowers the appellate authority to set aside an order of dismissal, removal or retirement issued under the rule, but also vests sufficient power, jurisdiction upon the appellate authority to pass such other orders as may be necessary in respect of the period of absence from duty of the person whose dismissal, removal or retirement has been set aside. Whether it was a fit case to set aside or modify the order of penalty imposed upon the petitioner was a matter which obviously have to be considered, keeping in mind the background facts and circumstances as well as the explanation furnished by the appellant. Full stop. However, as has been noted here in above, no such exercise appears to have been carried out by the appellate authority while issuing the order dated 18/11/2019. If that be so, the appellate remedy being a statutory remedy provided to the petitioner, it is a clear case where his statutory right under Rule 29 of the SSB Rules 2009 is seen to have been violated, and the interest of the petitioner, for which the interest of the petitioner has apparently suffered serious prejudice. The appellate authority, having been enjoined with a statutory duty, must perform the same upon due application of mind on the facts and circumstances of the case, and not by merely mechanically affirming an order of penalty, since the function of an appellate authority in these matters is not an administrative function, but is in the nature of a quasi-judicial function, which therefore, an order passed by the appellate authority must be clothed with proper reasonings and after due consideration of all relevant materials placed before it. For the reasons mentioned herein above, the order dated 18/11/2019 passed by the appellate authority is hereby set aside. The matter is remanded back to the appellate authority to reconsider the materials placed before it and pass a fresh order. The exercise be carried out and completed within a period
After giving an opportunity.
after giving an opportunity of being heard to the petitioner. The aforesaid exercise be carried out and completed as expeditiously as possible, but not later than 3 months from the date of receipt of a certified copy of this order. If the petitioner continues to remain aggrieved, now, in doing so, the appellate authority may also consider whether the facts and circumstances of the case would justify imposition of any other penalty short of dismissal from service. If the petitioner continues to remain aggrieved in the matter even thereafter, it will be open for him to approach this court once again by filing fresh writ petition. With the above observation, his writ petition stands disposed of. Upar, where I mentioned Mr. Bhatti has submitted this, there add one more line. It is also the submission of Mr. O.P. Bhatti, learned counsel for the petitioner, that the appellate authority had passed the order dated 18/11/2019 without giving an opportunity of being heard to the petitioner, and therefore the said order is bad on account of violation of principles of natural justice as well. We put it there where he said. Yes.
Much obliged.
Binding matter, item 3.
Wait, please, Your Lordship. We
Yes.
have sent our affidavit for waiting. Well, Lordship may grant us
You-
1
you
week.
File it in some other case. Since 2020, this matter is pending. There is a recommendation by SLC. What is your instruction, you tell me?
My instruction says, Lordship, that at that relevant period, Lordship, there was there was no vacancy and therefore it had to be rejected.
You appoint him against the next available vacancy. The recommendation of SLC cannot be diluted in this manner. Take down, heard Mr. J. Kalita, learned counsel appearing for the petitioner. Also heard Ms. M. Bhattacharjee, learned additional senior government advocate, Assam, appearing for the respondent number 2. Mr. I. Bhattakur has appeared for respondent numbers 1 and 3. Full stop. The father of the petitioner, who was serving as
Forester 1.
Forester 1 in the Forest Department, died in harness on 19/6/2008. Full stop. Having lost the sole breadwinner of the family, the petitioner, being the son, had submitted an application seeking appointment on compassionate ground in any grade 3 or grade 4 post on 25/8/2008. Full stop. At that time, there was no DLC available, and therefore the case of the petitioner was sent directly to the state level committee. DLC will be district level committee. By the resolution adopted in the meeting held on, what is the date of the resolution?
13 August 2014.
13 August 2014.
14.
The SLC had recommended
Page 53 Lordship.
the case of the petitioner for appointment against a vacancy of grade 3 post for the year 2010. Notwithstanding such recommendation, no action has been taken by the departmental authorities to issue order of appointment to the petitioner. Hence, this writ petition has been filed. First up. The state has not filed any affidavit responding to the prayer made in the writ petition, although this proceeding was instituted before this court as far back as in the year as far back as on 9 June 2020. First up. The Learned Standing Council Forest Department has merely submitted that there are no vacancies, as a result of which the case of the petitioner, as a result of which no order of appointment could be issued to the petitioner. Full stop. The said submission of the Learned Departmental Council is found to be wholly unacceptable. Full stop. A recommendation made by the SLC obviously would be preceded by proper assessment of vacancies. Full stop. Therefore, once the SLC makes a recommendation, the department would be under a bounden duty to carry out the same by issuing the consequential order of appointment. Full stop. It is completely unacceptable for the court to believe that since the year 2010, which finds mention in the recommendation of the SLC, no vacancy in the grade 3 category had arisen for issuing the order of appointment to the petitioner. Full stop. The petitioner had submitted his application on time, and the same also appears to have been processed by following the proper norms. Full stop. Therefore, once there is a recommendation of the SLC in favor of the petitioner, the same cannot be diluted by the departmental authorities by taking vague and unsubstantiated stand that there are no vacancies to accommodate the petitioner. Situated thus, this court is of the opinion that the petitioner has made out a good case for interference by this court. Therefore, this writ petition is being disposed of with a direction upon the respondent number 1, respondent numbers 1 and 3 to implement the decision of the SLC and issue order of appointment in favor of the petitioner within 3 months from the date of issuance of a certified copy of this order. Full stop. With the above observation is as per the recommendation made by the SLC. Within 3 months, receipt of certified copy as per the recommendation made by the SLC. With the above observation, writ petition stands disposed.
Lordship, in this case, I was supposed to file reply to the affidavit of the finance department, Lordship. Today I am filing this, so it may be taken up. next-
On the request to Ms. R. Devil and counsel for the petitioner. this
Lordship,
matter-
I have a further prayer, Lordship, but the PHC department has not filed any affidavit, and as per the finance department, Lordship, in 2005, more than 5,000, Lordship, workers and MR workers.
The
Lordship,
PH is not filed, will proceed that they have accepted your case.
Lordship, they may file, they may produce the.
We can't direct them to file
records-
affidavit, but
records.
if you don't file, that means they have accepted your case. That's how it goes.
It may
And
fix
the
it
Land
next
Council
week,
for
Lordship.
petitioner who submits that she is in the process of filing her rejoinder affidavit during the course of the day. This matter stands adjourned for 2 weeks. The respondents stroke departmental authorities may bring their stand on record within 2 weeks from today, failing which the writ petition will be taken up for disposal based on the materials already available on record. Office to list this matter again after 3 weeks by tagging the affidavit bracket S filed by the parties with the record of the case. Yes. Mr. P. Nayak, learned Standing Council Finance Department is present. And Mr. P. Nayak, SC Finance, and Mr. J.K. Goswami, learned Government, Additional Senior Government Advocate Assam are present.
The Lordship, I am appearing 7, Lordship. It's called 7.
P. Nayak for Finance.
Lordship, here in this case, in the last occasion, Lordship, this court, this honorable court, Lordship, directed us that to produce the record, Lordship. Record yet to receive, we send later, Lordship. I'll fix the matter in the next week, Lordship, we will submit.
Mr.
B. Laskar.
B. Laskar, counsel is present for the petitioner on the request of Mr. J.K. Goswami, learned Additional Senior Government Advocate Assam. This matter is directed to be listed again after a week so as to enable him to produce the record.
Fix a date, Lordship.
Huh?
Can you fix a date?
Come after a week.
May I please your lordship? Matters regarding lordship dismissal from service lordship. Assam Police. In the meantime, respondent number 5 filed their affidavit in opposition. We also filed our reply lordship.
Matter is ready as it is. Can be taken up for hearing.
Today lordship, date may be fixed lordship for hearing.
It means it's not today.
If lordship wants, I can.
But reply is not in our record, lordship.
All right, then you agree on a date.
Lordship.
Mrs.
No, we have no
Counsel for
problem.
petitioner submits
To
that
supply the bouquet.
his writ petition is ready as regards pleadings and therefore be taken up for disposal. Ms. M. Bhattacharjee and Additional Senior Government Advocate Assam appearing for the state submits that the complete record is not available with her and therefore the matter cannot be, therefore the matter be fixed on another date for final hearing. After taking note of submissions made by both the sides, this writ petition is admitted to formal hearing, registered to list the matter for hearing as a fixed item on 23rd of January 2020.
Deep review.
Obliged, your lord.
Yes, your lordship.
Yes.
This is a series of writ petition, Your Honor. I had joined CISF in the year 2001 on the basis of the scheduled tribe certificate issued to me. And in 2012, they had issued directions to me to submit scheduled tribe certificate in the standard format, which I had applied. Then I had filed writ petitions before the
Lordship, we need to file affidavit on this matter. We have sent it for vetting. Lordship may give us some time.
Acha, this notice was issued on October 2000.
October. I had even served the extra copy to them. They were present on that day.
So we'll give them one chance to file affidavit.
Yes, Your Lord.
Or Mr. S.K. Deori Land Council.
D.K. Deori.
D.K. Deori Land Council for the petition.
K. Kolita on behalf of KK Paraso.
I
CGC.
also heard Mr. K.K. Parasu, Leonard CGC, who submits that instructions are still awaited and therefore 4 weeks further time be granted for filing affidavit.
Your Lord, can a date be fixed?
Yes.
18th of January. 18th of January.
18th of January. You want it on 18th of
18th
January?
of January. Because now summer break will come after. Bihu break again.
On the request of the Leonard CGC, this writ petition is directed to be listed again on 18/1/2024 as a fixed item. Counter affidavit on behalf of the respondent be positively filed on or before 12th of January 2024 by serving advance copy upon the petitioner's count.
Obliged.
Right, please, Your Lordship.
Yes.
Lordship will kindly turn to page 18, my lord, of the contempt petition. 1A.
Yes.
Paragraph 16, this is the direction, my lord. Taking into consideration that the respondent authority, more particularly the appointing authority, still continues to place the petitioner under suspension in spite of the entire edifice of the impugned suspension order having disappeared. This court is of the opinion that the same constitutes an abuse of the powers for which the further continuance of the suspension of the petitioner is interfered with, and a direction is therefore issued upon the appointing authority, that is the Secretary to the Government of Assam Personnel Department, to forthwith reinstate the petition. But this direction was on, my lord, 17th of February 2023. Now we are under threshold of the December, my lord. Still not reinstated, despite having been interfered, still under suspension, my lord.
Well, we could file the affidavit today. In fact, on 14/11/2023, there is an order of the Honorable Court to file the affidavit by 18th. Before 18th, we could not file, and therefore, we have also filed an IA for modification of that order and
But
allowing us-
why is not been instituted? There is a direction.
In fact, the facts and circumstances we have narrated in the affidavit, my lord. After the order and the 17th of 17/2/2023 order and the other order of 2024/11/2022. In fact, a writ appeal was preferred, and after dismissal of the writ appeal, they have also explored the
My lord, misleading statements are being made.
No, no.
Against this order,
No, no.
no writ appeal was filed.
No, no.
Come on, my lord.
Mr. Patwari, you please take your seat.
My lord.
Let him-
Well, the writ appeal was preferred against the order dated 24/11/2022, 2022, Lord. And that is the basis, because considering that order, Honorable Court has said that the edifice on which the petitioner was suspended, it is no longer exist. So my lord, against that order, they have taken up the matter with the higher authorities, and ultimately, as per the advice of the higher authority, my lord, the suggestion was given to prefer appeal. But before they prefer an appeal, in the meantime, the private respondent, they have preferred an appeal, and the appeal was dismissed on 1st of June 2023. After that, again, the matter has been processed. Now, the competent authority has also suggested the department to take a report from the CID, whether the inquiry conducted by the CID officer, there was any mala fide or not. But recently, the Home Department has given a report that the inspector who has conducted the inquiry, as regard the caste verification, his report was a perfunctory report. We have annexed the communication in the affidavit in opposition.
Mr. Nath, I understand all this.
Because of the intervening circumstances.
But who is the personal secretary? What is his name?
Contempt of my lord.
He is the
Tanmoy Pradeep Borgohain. Full contempt.
But you have to, you can't just sit over the matter because you are not happy, you don't want this, you don't like this. Court orders are not subject to interpretation by the government. You have to either implement it or file a petition for suspending it, taking time. You cannot just sit over it. Otherwise, the whole thing becomes a farce.
In fact, they are not sitting over the matter. The matters are.
See how you are compelling us to direct your officers to come to court. How
But,
you are compelling us?
Lordship may kindly.
Because the court doesn't have any other option.
No, at this stage, kindly, my lord, allow us the IA we have filed, my lord, for accepting the affidavit on record, my lord, because the last order Lordship has said the affidavit has to be filed by 18th. Kindly allow us to just list the affidavit, the IA allowing the affidavit, my lord, take on record, my lord, and kindly consider the matter, my lord. Let the IA come and the affidavit come on record, my lord, and take it up on Monday or
But this
Tuesday, my
is
lord.
very sad. There is a categorical, you should have preferred an appeal against that if you had a problem with the order. Once these directions are issued or there is no application even for extending the time with reasons. Affidavit, you will say you are doing this, you are doing that, that's okay. But then the court had passed a final order issuing a direction.
But that
See, Mr. Nath, what happens is the court appreciates there are issues, but you cannot chart your own ways of dealing with court orders. That we will not allow. This court will not allow. Then we would like to see, we would like to test the limits of the constitutional boundary. You can't do it. That you have passed an order, we'll see if we like it, we'll implement.
No. That is not.
Is not happening.
No, that is
If
absolutely
that
not.
is the attitude, then we would like to see.
No.
How far it goes, we'll go.
That is absolutely not the. That is not.
But how can it be done? This order was passed when?
17th of February
17th of
2023.
It is on 17th of February, my lord.
8 months, 9 months, you do nothing.
My lord, steps are being.
Tell him to come, the personal secretary of the.
No, Lordship may kindly take up the affidavit on record, my lord, and the along with the IA, and on the next day, my lord, Lordship may kindly consider. And
I'm not disputing one. There was an order from this court.
Mr. Patwari, this court is not appreciating that
I'm
you are
sorry.
interfering.
I'm sorry.
We'll of course give them a
I'm sorry.
chance. We'll
I
fix it
apologize for
next
that.
day.
I apologize.
Mr. J. Patwari, learned counsel for the petitioner, also heard Mr. D. Nath. You are appearing for the respondent.
For the
right?
respondent.
Learned counsel appearing for the sole respondent, who submits that the interlocutory application as well as the counter affidavit. No, counter as well as the affidavit filed by the sole respondent in this case are not on record. And therefore this matter be taken up along with the along with the connected records. In view of the submission made by Mr. Nath, registry to tag the affidavit filed by the respondent with the record of this case and list the matter along with IA number.
I have the filing number, my lord.
Along with the
File
IA
it today.
supposed to be filed by the petitioner, by the respondent. Again on 6th of December. 6th of December. We'll see what happens. You come prepared with your legal, whatever you have. But Mr. Nath, this is not a happy situation. We'll record that the officials are compelling the courts to direct personal appearance.
But I'll definitely take that.
There are ways and means of doing things.
But anymore.
If you are not happy with the order, you should come back to the court. Otherwise, what is it turning out? That the secretary is becoming the appellate court of the High Court orders.
No. That is not.
He will certainly not allow that to happen. You tell your officers.
Definitely.
You should be very, very wary of what is coming. And I will mention it that they are compelling the courts to do this. You can't do that. You may have difficulties, we understand. You may have genuine reasons. You are running administration. You may have very, very good and genuine reasons. But then court orders can't be left like this. High Court orders cannot be left like this.
I've taken note of this.
Yes.
Deeply obliged, madam.
But can this be on 7th, my lord? 7th or 8th?
All right, 7th.
Lordship. Acknowledge.
My lord, here office note dated 23/11/2023, my lord. Service is complete, my lord, on all the respondents. And they have appeared also.
Mr. P.K. Muni, learned counsel for the petitioner submits that as per office note dated 27/6/2023, service is complete on all the respondents. Miss
J. Bathari,
J. Bathari, learned counsel, has appeared on behalf of.
D.K. Roy.
No, you have to tell me the name of the respondent. D.K. Roy is not a respondent.
All the private respondents.
All the private respondent 5, 6, 7, 8,
We have
11.
private respondent numbers 5-2.
5, 6, 7, 8, 11, 12, 14, 15, 16, 17, 18, 19, 20, 21, 22.
Here, respondent number 10 has expired, office note says, ma'am.
You give it in writing.
Yes.
And Mr. CKS Barwal and G Assam is present on behalf of respondent numbers 1 to 4. Upper to Didibo, Professor Echini. Mr. Munir submits that the respondent number 10 has expired, but there is no requirement to file application for substitution. You don't want to file application for
No,
substitution. In view of the above, refuse to verify. And if it is found that all other respondents are served, this matter will be listed for admission.
But here also, my lord, the Lawazima report, my lord, 24/11/2023, my lord, the service is complete.
Mr. P.K. Monil and counsel for the petitioner submit that as for the Lawajima court.
24/11.
24/11/2023, this matter is ready as regards service. Who is for the state? Mr. CKS Barwal and Government Advocate Assam is present on behalf of the respondent number 1.
Lordship, I am for respondent number 4, BS Dekal.
Whereas Mr. B.S. Dekal and a counsel is appeared for respondent number 4.
No, that is.
The respondent number 2 and 3 can be represented by the learned standing counsel Guwahati High Court. As such, the registry to list this case again for admission after 2 weeks by reflecting the name of learned SC GHC as the counsel for the respondent numbers 2 and 3.
I'm deeply obvious.
All it, let's see.
For hearing item 13.
Wait, learned senior counsel, Mr. Ken Chudhary, he has some bereavement. Because one of his senior, elder brother yesterday expired. So may I pray to at least 3 weeks time only?
No, I have no issue. I cannot have an objection.
Don't give it now, don't give it now, keep it.
The Lordship keeps the matter part heard. I may pray for that because the Lordship had extra issues.
These are part, it's shown as part.
Yes.
Mr. M.K. Sharma and counsel.
M. Sharma.
M. Sharma and counsel is present on behalf of the read petitioners. Mr. R. Goswami, learned counsel for the private respondents appearing in this batch of read petitions. Save and accept item. And accept
Item number
15.
16.
Item 15.
Yes.
16.
Have
16.
submitted that although this is fixed as a part-heard matter for further hearing today, yet the learned senior counsel engaged in this case, namely Sri K.N. Chaudhary, has suffered a bereavement in his family yesterday, as a result of which he is unable to come to court today. As such, a prayer has been made to list these cases again after 3 weeks for hearing. The prayer is not opposed by Mr. Sharma, learned counsel for the writ petitioners. Mr. C.K.S. Barwal, learned G. Assam, and Mr. R. Majumdar, learned counsel for whom?
The private respondent.
For the other private respondents are present and also do not have any objection. Your opinion? Ms. P. Sharma for APSC are present and do not have any objection to the prayer for adjournment. In view of the above, registry to list these cases for further hearing again after 3 weeks.
Yes.
If I may pray, if the
Part-heard matter will come. No, what date? Fixed date.
date.
Fixed part-heard matters will.
Oblige.
I'm grateful enough.
Yes, what is this item?
Lordship, this is a 2012 matter, Lordship. Here the petitioners are female workers, my lords, and they are challenging an advertisement that was mainly fixed for male workers, my lords, by the health department. An advertisement was issued by the authorities in the
We
DHS.
will have to sit at 2 then.
Lordship.
That's not, yes.
Item 18.
Yes. Lordship.
What is there in this case?
Lordship, item number 18, my lords, there was an advertisement on 2011, my lords, for multi-purpose workers, male, my lord. Here, the writ petition has been filed saying that it's in violation because 3 of the writ petitioners, they are females, my lords. And 2 of them are male workers, but they do not have the requisite qualification, my lords. We have stated that in our affidavit, my lords. So whether anything survives at this stage, my lords, I learned it.
Nothing survives.
My lord, this I am the female. I am the petitioner number 1 is the qualified educational qualification.
Female, my lord.
Female. I am challenging my lord, the advertisement, well, the female maybe, my lord, this opportunity to, my lord, to
Lordship, if
give
I,
the job, my lord.
Lordship, there's a post for multi-purpose workers, females also, my lord. So there are two different
But
posts.
what has happened to the advertisement?
Lordship, the selection process.
Advertisement, my lord, page number 31, my lord.
So it is subject to outcome. Any appointment has been made.
Appointment has been made,
I-
Lordship. Lordship, if I can just take my Lordship through our affidavit, my lord.
No, where is the advertisement?
Advertisement.
My lord, my writ petition 31 page, last page. Multi-purpose work, mail.
Lordship, in the second line is written male, Lordship, specifically.
So what is the ground of challenge of this advertisement?
Advertisement, my lord, this, I am the, my lord, this, as per my lord, article 14, 15 and 16, my lord, this, I am the female, but my lord, I am the qualified in petition number 1. As per advertisement. So maybe, my lord, the opportunity to, my lord, this as per qualification, my lord, I am the female.
Female, Lordship.
Female, but advertisement is male, and others, my lord, he is not qualified, even then he is the other qualification for male and female.
Not.
If, my lord, this petitioner number, accept petitioner number, my lord, 1, other is not qualified, even then, my lord, petitioner number 1 is the, my lord, qualified for female, and male qualification and female is the same qualification, deprive the female. That is my. Why not, my lord, the
So petitioner numbers 2 and 3 are male.
Yes, my lord, and they do not have the requisite qualification, my lord. For males. And
So,
one is the.
right, yeah.
This
Heard
is
Mr. Jahangir,
One is
counsel
the,
for
my lord,
petitioner.
qualification.
Also heard Mr. H. Ali, learned Standing Council Health Department Assam appearing for all the respondents.
yes, Lordship.
Hmm.
Lordship, not for respondent number 4. 1, 2, Lordship, 1 and 2.
1 and 2, none has appeared for respondent numbers 3 and 4. The advertisement notice dated published in the Assam Tribune, Union Courts, in its issue dated 30/10/2011. Issued by the Director of Health Services, Assam, for filling up 900 posts of multi-purpose worker, bracket male, has been assailed by the 5 writ petitioners by filing the instant writ petition, inter alia contending that the advertisement notice violates their rights, full stop. Although no interim order was passed by this court, yet in the order dated order dated 13/12/2012, it has been mentioned that any appointment made to the post of multipurpose worker shall be subject to outcome of the writ petition. The respondents numbers, who has filed affidavit?
Lordship,
Respondent number 2.
Director of Health Service, respondent number 2.
Director of Health Services has filed affidavit wherein he has stated that the advertisement having been issued for male candidate, no female candidate can assail the same. Mr. Cholia submits that out of the 5 writ petitioners, the petitioner numbers 2 and 3 are
Males,
male
but-
candidates,
Yes, but
but they do not fulfill the
requisite qualification, Lordship.
requisite qualification norm. Insofar as the petitioner numbers 1, 4 and 5, they being female
Females,
candidates, do not have any locus standi to challenge the advertisement notice. The said contention of the learned departmental counsel could not be refuted by Mr. Jahangir, learned counsel appearing for the writ petitioners. If that be so, and considering the long lapse of time since the advertisement was issued, nothing further survives for being adjudicated in this writ petition. Consequently, the writ petition stands closed.
Item 19.
Yes,
Matter pertains to dismissal from service, my lord. The petitioner was serving as a, my lord,
date, tell me which date.
my lord.
Yes, the only thing that you can argue now is for a date.
Subject to my friends.
Agree on a
Only
date.
thing like, from 13th, I will not be there for 4 days.
You
Any
fire,
other-
sort out a date.
My lord.
Mr. So-and-so for petitioner, so-and-so for this, for the respondents. On the joint request of learned council for both the sides, let this matter be listed again on dash. for
4th
final
of January, my lord.
Yes.
Oblige.
May I please, your lordship? The matter may be taken next week, your lord.
On the prayer of learned council for
short
the
date may be
petitioner,
given.
this matter, hearing of this matter stands adjourned for a week. Mr. J.K. Usami, learned additional senior government